order of the adjudicating authority and upon the appellate tribunal. Then, my lord,
What was found in your search? Only
some
punch paper and
nothing. Then, my lord, can come to again. They have come, my lord. This is 75. My lord, I have given one copy of the Panchinama. What happened on 9 October 2025, 10 October 2025, 11 October 2025. On 3 days, they have conducted such and such in the restaurant of the petitioner and the office of the petitioner and the restaurant of his son and his daughter.
9th October 25?
Yes, 9 October 2025, 10 October 2025,
yes.
11. So those documents articles are there.
Yes.
They have 15 lakhs rupees on the restaurant of his son.
Yes.
Then, my lord, they have, well, can you see? And you can come to page 98.
What out color?
97 should have. So, my lord, at first 97, his daughter was called for recording evidence at first 97, my lord.
Yes.
At first 97, she was called and she went to attend and recorded, gave her evidence.
Yes.
And then, my lord, can come to page 100.
Here.
The petitioner's wife was called for.
Yes.
She also appeared and submitted all documents, recorded all evidence. But then, my lord, 103.
Yes.
His son was called. His name is Samudra Bose. He was called.
Yes.
He went to the officer concerned and recorded his submission for produce the documents.
Yes.
This happened on 11 November 2025 and onwards, my lord. But here, my lord, I see. Now, my lord, thereafter they filed an application under subsection 417 for retention of the 6 articles. In that application, they have annexed an application under section 8 for adjudication, where they have disclosed what is the allegation against the petitioner. I just have to pay 115.
Yes.
It starts from 109. My lord, starts from 114 is a recording of reasons under 8(1) of the 114, my lord. Is it 14, my lord?
114?
Yes.
Yes.
This is recording of reasons under subsection 8, 1 of subsection 8 of the PMLA Act.
Yes.
It is given along with my retention application for retention of the goods.
Yes.
Therefore, here is at page 115 C and D. Sujeet Bose, former Vice Chairman, South London Municipality, for the period 10 to 21, and incumbent Minister of State Independent Charge, Department of Fire and Fire, played a pivotal role in influencing and manipulating the recruitment process by recommending candidates for illegal appointments and by forwarding list of candidates proposed by other political exposed persons. Sri Sujeet Bose recommended multiple candidates for illegal appointment in South London Municipality. Accordingly, details of all candidates recruited pursuant to notification onwards or requisition for South London Municipality. Several candidates recommended by Sujeet Bose are appointed by the municipality.
Yes.
This is the addition.
And then it may read A also.
Mr. Bala?
E also.
Yes, sir. Thank you, sir. She was in conclusion, his associates initiated the recruitment process by facilitating the appointment of the undeserving candidates. So this is the allegation against him. Now, we can see, can we come to at page 120. The CBI filed a charge sheet.
Yes.
CBI filed a charge sheet on 30th June 2024.
Yes.
In the charge sheet, the name of the petitioner was not implicated.
Not implicated.
No, not implicated.
Yes.
Yes, my relevant page 27.
127.
The name of Anshul, the chairman of Procedural right, the chairman of the subcommittee was,
Where
is
is,
127. Sorry.
where is the conclusion in the charge sheet?
It is 127.
127. After completion investigation, Ayan Sir and Panchu Gopal Roy.
So my name was Anshul, I got the agency,
Bhavanadipur.
he is the chairman of the.
Bhavanadipur.
Yes.
My name was duplicated. They file again supplementary charge sheet.
Hmm.
This is Act 130.
Yes.
This is 30th December 2025, they filed charge sheet, but the concluding parties 155. Yeah.
List of witnesses.
No, sorry, madam. Then come to start, no, it's 153, sorry, madam.
156.
53.
53. Yes.
My lord, this is the, that's the original, the director ABS was the mastermind, you got it, madam?
Yes. Yes.
In the forgery of answer scripts and manipulation of the marks of the written examination conducted by the purpose of recruitment of staffs at different municipalities. The forgery of documents took place in the office of ABS Limited, the close supervision actual accused Sionshil. Similarly, Josna Mon Chaudhary Chattopadhyay IS, the director of the Directorate of Local Bodies, entered into criminal conspiracy with Pachi, the then chairman of South London Municipality, and in order to such conspiracy illegal approved the appointment of 29 persons to the post of Mazdur and peons at South London Municipality, for which no process recruitment was ever conducted in the same municipality.
So you have not been.
I am not getting good.
Correct.
So, my lord, in the predicate of the residual offense, she can see on 15 March 2026, my lord, the election was declared.
Hmm.
It's a notification. I know I have been nominated as a candidate of All India Trinamool Congress from Bidhanam constituency. 29 is the election, my lord. Now you also, they can see their action. Can you come to page 156?
Yes.
On 2nd April 2026, I've been called. Was you got it, man?
Yes. Yes. Yes.
On 6th April 2002, attempt to take out my statement under section 50, my lord.
What is the notice of date of the notice?
This is notified
2nd April.
2nd April.
Yes.
So I've been asked to appear before them in person to record my evidence under section 50 of the PMLA Act, my lord.
Correct.
After getting this receipt of this, I gave them a letter at page 159.
159.
Yes. I said, I understand I have received the above report now someone wherein I have been asked to appear in state authority at your office, give evidence in connection with the investigation and proceeding under the PMLA Act. I have been meanwhile nominated as the candidate set up by All India Trinamool Congress, represents the political Bidhannagar Assembly in the NC election in West Bengal. Considering I am being preoccupied by campaigning, holding possession, public meetings in connection with the ensuing assembly election and other allied activities. Particularly, I will submit my nomination paper on 6 April 2026. In the aforesaid genuine causes, I am unable to condition to appear.
Yes.
So I've been asked them to give me time after election poll. I am ready. Although my name is on charge sheet, I'm ready to go.
Okay.
Name, my lord.
So you are requested for time.
I only got after election poll.
Okay.
And 160, my lord.
160. Yes.
Again, they have given 7 April at page 60. I asked me to appear on 9. Page 161, the date is given, my lord.
Yes.
So, 7 and I again called to 7. Again, I wrote a letter to the at page 163.
What is the date fixed? 9th of
9.
Yes, 9th April. Yes. Then
I wrote a letter at page 160. I wrote a letter. I said, kindly allow me. You at page 163.
Hmm.
They turned to this request. They again issued a show cause at page 164. Page 164. Date is page 165, 9 April 2000. On the very same day, they have issued again show cause notice.
Yes.
Asked me to appear on 11 April 2000.
Not so cause summon.
Yes.
Summons to
Yes, summons. That is success summons.
Yes.
164, again I've been asked to appear on 11 April 2026.
Correct.
Now, my lord, you can see what is it.
So what has happened 9th April?
And then I just go the section that I'm.
No, 9th April you have appeared or not?
No, my son went as an authorized representative, but I just didn't about it. And you also can see section 50, section 3. I have to go to English. What are we doing? I come to section 50,
Section?
50.
Yes.
Under this section, I have been asked to attend.
Correct.
So can you see the subsection 3?
Yes.
All the persons so summoned shall be bound to attend in person
Yes.
or through authorized agent.
Correct.
As such, officer may direct and shall be bound to state the truth upon the subject. So, subsection says, myself, I can appear personally, or my authorized agent may appear for purpose of recording evidence or production of documents. On the basis, in terms of this section, I sent my son. Also, kindly come to page 167.
Yes.
My son went to them.
Hmm.
Can you page 167?
Yes.
I wrote to them that my son and I'm sorry to articulate that I have divulged the genuine causes in my earlier letters as to why I was not in position to appear before your esteemed authority on 6/9 for giving evidence. Since I am contesting the state assembly election here on 29 April 2026 as the candidate all in the Trinamool Congress, a recognized political party from 100 Assembly constituency. I have prayed for the time till 15 May 2026. Unfortunately, my prayer was turned down and immediately I have been asked to appear before your estimate on 11 April 2026. I have been legally advised that since subsection 3 of section 50 of the provides that all the persons who summoned shall be bound to attend in person through authorized agent, as an officer may direct shall be bound to state to the such and such. My son, namely Somito Bose, having been my authorized agent, will appear before your esteemed authority on 11 April 26 to give evidence in connection with the investigation. But this is my letter. Next on my authorized authority. Next one, general authority.
Yes.
167 was the letter authority and 170 is my general authority given to my son.
Yes.
My son went there. They accepted my letter, but they did not allow my son to appear to attend for recording evidence. And now, in this situation, they again now serve the notice, summons at page 174. Judgment Roberto.
Yes.
Page 74.
Yes.
Again, I've been asked to appear tomorrow, 24th April 2026.
Yes.
In person. I've been asked to appear now in person.
Correct.
This is the date.
I agree with this. I have come before Lordship. My submission, just I see. Can you go more? Must be the Madam. The 18 is online. Madras 14055.
Message them 2000.
Sorry, 10.
2018 SEC online
Right.
address.
Now you can you press paragraph 91, 92.
Can you repeat the citation, please?
Just a minute. So it is 2000 online, but class 1.5.
You're not audible.
online Madras.
Also, can you come to paragraph?
I can't, can you give the citation again, please?
1-4. Come to page 91.
CC online. CC online. Madras 14.
14?
055.
You're not audible, sir.
2018 SCC Online Madras 14055.
Thank you.
Any paragraph 91. Subsection 3 of got it, man?
Yes, yes.
50 states that the persons who receive such summons from the competent authorities under the PMLA is bound to attend in person. However, the authorized agents are also permitted to attend the investigation on behalf of the persons against whom such summons was issued. However, if the competent authorities under the PMLA is of the opinion that personal appearance is required for the purpose of seeking certain specific clarification, then the scope of the act is wide and the authorities competent are empowered to issue summons for the personal appearance of a person to participate in the investigating process. So my submission is that why my son was not allowed. Why have been asked to in question? They have not given any confirmation that for this purpose you have to should appear. And these are one this, my lord, issue I am submitting to your lordship. That side you should come in person. I sent my son that he was without. He was not said when he was asked in person. No, he was given the purpose. And in this context, my lord. Only the 24, 7 SSC. 7 SSC, 576.
576.
Can you come to paragraph 26, my lord?
Just a minute, let me. So
Can you give the citation, please?
So it is 2024.
Is it?
2024? You're not audible.
2024 volume 7 SCC 576.
এই মাইকটা কাজ করছে
Pankaj Bansal.
Yes. Can you come to paragraph 26, my lord? You got it, my lord?
Yes.
Paragraph 26. Being a premier investigating agency, second line, charged with
Paragraph?
26, my lord.
Yes.
This line will start at second line. Being a premier investigating agency, charged with the onerous responsibility of curbing the debilitating economic offense of money laundering in our country, every action of ED in the course of such exercise is expected to be transparent, above board, and conforming to prescribed standards of fair play in action. ED, mantled with far-reaching power under the Stringent Act of 2002, is not expected to be vindictive in its conduct and must be seen to be acting with utmost probity and with the highest of discipline. My submission is that after declaring the election, they have called me. I said I am ready to go. After send my son, they did not accept it. They called my you should come in person, consider my election, and that is not been said. Now, my lord, after this, my lord, I lost my submission is that, my lord. This is now, my lord, can you see they are initiate the proceedings, the investigation in respect of recovery of the proceeds of crime. In respect of that predicate offense or civil offense, my lord. This one judgment. This is very voluminous. My lord, come to paragraph 109.
Vijay Madanlal Chaudhary.
Yes, yes.
Vijay Madanlal Chaudhary submitted the mistake. Just send some.
109, madam.
Paragraph 109.
It's so voluminous, my lord.
Yes.
Just please. Towards the put, it is only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offence that can be regarded as proceeds of crime. The authorities under the 2002 Act cannot resort to action against any person for money laundering on an assumption that property recovered by them must be proceeds of crime and that the scheduled offence has been committed unless the same is registered with the jurisdiction of police or by way of complaint to the competent forum. So my suggestion that the CBI has registered the case, and in that they find the charge sheet. My name was not in.
This one, no?
So they have the right to conduct any investigation or
Why the ED cannot ED cannot investigate or inquire a separate inquiry other than the CBI inquiry?
no, the section 3.
Nice. The question is that
Yeah, I understand.
CBI has initiated an FIR, submitted charge sheet, inquiry, investigation submitted. Whether the ED cannot inquire into the matter further.
Well, my answer is that with regard to section 3 for possible crime, they can't. But it is that civil offence or the predicate offence under the PMLA Act. Here, the court says that case should be registered to jurisdiction of police. That case on the same stand. They launched the charge sheet. My name was not there. But that they can speak for to deny the procedural crime under section 3 in respect that predicate offence or not, madam. But this is but now I'm not going to this question now. But only here, my lord, I'll be allowed to I'll go there. My son should be allowed to go there tomorrow. Now.
Okay. Yes. Yes.
Yes, my lord, may I submit my number 1? His not being there in the predicate offence is of no consequence. I'm relying on a judgment of the Supreme Court directly on this point. That is Pavana Depot's case. The citation is 2023 SCC online SC 1586. 2023 23 SCC online SC 1586.
Lordship,
My colleague would be there. He probably will hand over
I
the
just
copy.
came, so my lord may have a document.
Para 17 may be looked at. It is only when the entire predicate offence goes that a person who is not named in the predicate offence can get an exoneration in the PMLA offence. May I read para 17, my lord? Coming back to section 3, my lords have got para 17.
Just a minute.
Just a minute.
I'm going to read you.
Yes, print out. But I apologize, my lord. 1 second, my lord. Impromptu, my lord.
No problem. Para 7?
17.
Para 17.
17.
Yes.
Yes.
Coming back to section 3 of the PMLA, on its plain meaning, an
Yes.
offence under section 3 can be committed after a scheduled offence is committed. For example, let us take a case of person who is unconnected with the scheduled offence, knowingly assists the concealment of the proceeds of crime, or knowingly assists the use of proceeds of crime. In that case, he can be held guilty of committing an offence under section 3 of the PMLA. To give a concrete example, the offence under section 384 to 389 of IPC relating to extortion or scheduled offences included in para 1 of the schedule to PMLA. An accused may commit the crime of extortion covered by section 384 to 389 of the IPC and extortion. Subsequently, a person unconnected with the offence of extortion may assist the accused in concealment of the proceeds of extortion. In such a case, the person who assists the accused in a scheduled offence for concealing the proceeds of crime of extortion can be guilty of the offence of money laundering. Therefore, it is not necessary that the person against whom an offence under section 3 of the PMLA is alleged must have been shown as an accused in the scheduled offence. What is held in paragraph 270 of the decision of this court in Vijay Madan Lal Chaudhary supports the above conclusion. The condition precedent for attracting offence in section 3 are that there must be a scheduled offence There may be proceeds of crime in relation to the scheduled offence. Therefore, his involvement in the scheduled offence or his not being named in the scheduled offence is of no consequence as long as the scheduled offence exists. The charge sheets have been filed, therefore, prima facie support that the scheduled offence has taken place. Therefore, submission that I am not there in the scheduled offence is contrary to law that I should be exonerated on. But that is beside, he is not arguing for quashing of the ECI or quashing of the proceeding. He's just asking for summons. He's arguing as if he's an accused. Today he's been called on the basis of a summons. Summons issuing a summons doesn't make him an accused, sir.
No, that is correct, but he is only telling that he will cooperate with your inquiry or investigation, whatever it may be. But he requires some time because he is the contesting candidate and he requires some time. And after the election date, he will appear. So what is submission on that? What
On
is
that, firstly, he
the
says
requirement of the petitioner to appear before you on 24?
his case. I'll come to that directly. Son can't come because if a person is convicted, he can't say, I'll send my son to jail.
No problem. If you're not allowing the son, let he give some time to the petitioner.
His case is that as soon as the campaigning is over, I'll come. The campaigning will get over on 23rd. So he can come on 24th. Look at his first reply. His reply is, as soon as the campaigning is over, I will come. So let him come on the 23rd or 24th when the campaigning is over, or 27th when the campaigning getting over.
So for
26th, I'm told campaigning getting over on 26th. Let him come on. Let him come as soon as the campaigning is over.
1 or 2, what will affect that? If he will be allowed to appear before the authority on 2nd May or 1st May,
4th is a result after 4th month.
what will be effect, Mr. Raju?
No, it is his case. It's not a question of he says I can't come because I'm busy in campaigning. It is his case.
No, I'm not saying
His
this.
initial case is his case. I'm not saying that he should come. It is his case, though. Therefore, I'm agreeing to his case.
No.
Let him come on to. He says,
It's not-
kindly
I'm
look at
not
his first.
saying this.
Kindly look at his first reply, sir. His
Yes.
reply is, I'm busy in campaigning. Moment is my iPad. His first reply, he says, I'm busy in campaigning.
One. At page 159.
Reply is at page 159.
Yes.
Just give me a minute, brother.
Say this. At 7:15 May.
Preoccupation. Kindly have a look at paragraph 2. I have been meanwhile nominated as a candidate set up by so and so, recognized political party and so and so. I am being preoccupied for campaigning, holding processions and public meetings in connection with the So I have nomination. So campaigning he can do. He can come as soon as the campaigning gets over on 26th. He may come on 27th.
Then
it is his own case that I'm required for campaigning. He doesn't say anything else.
Okay.
If he doesn't say anything else,
then I said
therefore, when his case, he has put up a case that I'm required for campaigning. All right, let him do the campaigning, come on 26th or 27th when the campaigning is over.
we have the 27.
Okay. Any further?
That's it, Manu.
Yes, sir. You are appearing for?
Otherwise, the petition. Otherwise, there are legal submissions. Petition challenging a summons is not maintainable. He has to comply with the summons. There are judgments to the effect. May I cite a few judgments on this point? The petition challenging the summons is not maintainable.
You challenge the summon or you?
I'm challenging. Like I said, not to be.
Therefore, essentially challenge the
Then I
summons.
said I'd be allowed
The summons requiring him to come on 24th is challenged.
Or then
He's challenged the sum. So far,
recall and set aside the summon.
We call this next, and alternatively I ask them to allow me.
so if the petition is not maintainable, there can't be any relief in a petition which is not maintainable.
Okay.
So my first contention is petition is not maintainable. I have 3 judgments to cite on this point, and those are the compilation there. Those are One is Kirti Simankar.
My lord, we are handing over the compilation.
The petition is premature. It doesn't give him a right to challenge. Someone says just come and record your evidence or give your document. That's all. That can't be challenged in the writ petition. Those are these 5-6 judgments which I'm citing to save the time of the Honorable Court. I'm not reading the, but as far as someone show cause
Paragraph,
notice.
which paragraph?
Yes, madam. Kindly come to first Kirti Samankar.
Yes. Paragraph.
Paragraph, kindly come to page number 3.
Paragraph 3.
Page 3, page 3.
Page 3.
Page 3, yes.
No paragraph.
Which SEC online? You are referring the SEC online?
No. My lord, the first one, which is
It's a print.
this
Now
Suman.
kindly have a look at page 1. Page 1.
Page 1.
Okay.
In the course of hearing of the writ petition, we find that the writ petition was premature. Petitioner seek for the prayers that have been counted in the writ petition, where the petitioner pray for issuance of mandamus to determine the question of as to whether allegations of commission of so and so would constitute a bailable offence, if any, under custom. In fact, when we peruse the averments contained in the writ petition, the provocation for the petitioner to file this writ petition was so-called such conducted residence premises of the petitioner so and so. It is further averred therein that the officer threatened that the petitioner would be arrested, incarcerated in jail, and if they are considered if he did not submit to dictate. On that basis, the writ petition came to be filed in this court under so and so. We therefore express that it was highly premature for petitioner to seek for an extraordinary constitutional remedy under 32 of the Constitution based on such preliminary averments contained in the writ petition. Inasmuch the averments cannot form the basis of prima facie apprehension of arrest. We therefore also express that the writ petition does not merit any consideration to be dealt with on various issues raised, inasmuch as it will be appropriate for petitioner to work out his remedy as and when an appropriate positive action is taken against the petitioner. Then, my
Yes.
lord, kindly have a look, my lord.
Yes.
Page 10. Next judgment of this same Kirti Samankar, my lord, page 10, which is the next judgment.
Page.
Page 10 of that compilation.
Page 10.
Yes.
Para 1.
Yes.
By consent, the impugned order is set aside. However, we wish to make it clear that as far as possible, the High Court should not interfere at the stage when the department has issued the summons. This is not one of those exceptional cases where the High Court should have interfered at the stage of issuance of summons. It will mention that all of the questions of merits are therefore summons stage it should not interfere. That is the. Then my lords may look at the third judgment, CM Ravindran.
Yes.
Page 14. Para 8. The learned ASG raised a preliminary objection regarding maintainability of the writ petition. We contended that the writ petition is liable to dismiss as premature since the issuance of summons under Section 50 of the Act does not give rise to any cause of action. In support of this contention, reliance was placed on the decision of the apex court in Kirti Samankar and so Kunnu Shetty. In Kirti Samankar, the petitioner approached the apex court after official custody but conducted a search in the resident premises of his former wife. Petitioner alleged that he was threatened with the arrest of him. If he did not submit to dictates of the custom officer, the apex court observed that it was highly premature for the petitioner to seek remedy under 32 of the Constitution of India. Based on such principles, in Kunnu Shetty, the appellant had approached the court of being served with a show cause notice by his employer regarding the genuineness of caste certificate. After adverting to precedents of the proposition, ordinary no writ would lie against the charge sheet or show cause notice. The apex court held us with that. The reason why ordinarily a writ petition should not be entertained against a mere show cause notice or charge sheet is that the petition be held to be premature. Mere charge sheet or show notice does not give rise to any cause of action because it does not amount to any adverse order which affects the rights of the parties unless the same is issued by the person having no jurisdiction to do so. So kindly have a look. If a summons is issued, the writ petition is not the remedy. It's apprehending arrest, which is, I feel, is not even his case. He should file an anticipatory bail. But approaching the court as far as the petition is concerned, which is premature. Then kindly have the next judgment. Page 54.
Yes.
Delhi High Court judgment, my lords.
Yes, page 54, paragraph.
Para 141.
Yes.
The enforcement officers empowered by PMLA to make investigation into offences under the said law are not to be empowered under offences and said law are not to be equated to police officers. Law confers upon them requisite power to carry on the investigation, collect evidence. Said power includes the power to issue summons to any person whose attendance is considered necessary and compelling assistance, whether to give evidence or to produce any record and examine an oath in terms of section 50, subsection 2 or 3, to put any person under arrest without warrant upon satisfaction as to his company. These powers are necessary for investigation, do not render the authorities under PMLA same as the police. General guidelines governing the arrest procedure as envisaged in Code of Criminal in terms of judicial control, the exercise of such powers by them. The fundamental rights relating to criminal prosecution in general against self-incrimination in particular are not denied here. Similarly, rights guaranteed in arrestee, including authorization, continued as per so and so, continue to regulate, and for this purpose, section 167 continues to apply so and so. Therefore, my lord, there is no allegation that we are not authorized.
Yes.
Now, kindly have a look at my other compilation, which is person summoned under section 50 of the PMLA is bound to appear in person.
Which page?
Now, this is the new compilation, para 425 of Vijay Madan Lal, which is at
Mellots already have
I've-
that.
I've given
that
this.
Which page?
page number would be page number 3, because since the Vijay Madan is the longest judgment, I've only extracted relevant paras. Kindly have a look at page 3 where para 425 is extracted.
Yes.
Indeed, subsection 2 of section. My lords have got it?
No. Page number 3.
Yes. Where para 425 Vijay Madan Lal is extracted.
That compilation. We have just carved out those pages for Vijay Madan Lal, which we are relying upon.
Yes.
Indeed, subsection 2 of section 50 enable the director, additional director, joint director, deputy director, assistant
Once again.
to issue summons to any person whose attendance is considered necessary for giving evidence or to produce any record during the course of any investigation or proceeding under this act. We have already highlighted the width of expression proceeding in the earlier part of this judgment and held that it applies to proceeding before the adjudicating authority or judgment and held that it applies to proceeding before the adjudicating or the special court as the case may. Nevertheless, subsection 2 empowers the authorized officer to issue summons to any person. We fail to understand as to how pursuant to such summons is only for the purpose of collecting information or evidence in respect of proceeding under this act. Indeed, the person so summoned is bound to attend or through authorized agent. Authorized agent when the summons says so. In our case, it doesn't say so. Discretion.
I have been here, sir.
So someone bound to attend and state the truth upon subject concerning which he may be examined or expected to make a statement and produce document as he may be required under subsection 3 of so and so. The criticism is essential because that is then my lords may come to the next judgment. Page 17, Veerbhadra Singh. Page 73, Your Honor. Lordship. Page 73 of that compilation. Para 143.
Yes.
It is clear from the above discussion that Prevention of Money Laundering Act is a complete code which overrides the general criminal law to the extent of inconsistency. This law establishes its own enforcement machinery and other authorities with adjudicatory powers and jurisdiction. The enforcement machinery is conferred with the powers of jurisdiction for investigation. Such powers being quite exhaustive to assure effective investigation, built-in safeguard to ensure fairness, transparency, and accountability at all stages. The powers conferred on the enforcement officers for the purpose of complete and effective investigation include the power to summon and examine any person. The law declares that every such person who is summoned is bound to state the truth. At the time of such investigative process, the person so summoned is not an accused. Mere registration of ECR does not make the person an accused. He may eventually turn out to be an accused person upon being arrested or begun are being prosecuted. No person is entitled to evade the command of summons issued under Section 50 PMLA on the ground that there is possibility that he may be prosecuted in future. The law declared in Nandini Satpathy concerning statements of 161 CRPC recorded in other pronouncement concerning similar powers of the officer, as noted earlier, provide a complete answer to apprehensions which we have expressed. Then, my lords, may kindly have a look. Then, Tamil Nadu judgment, my lords, page 134 of this compilation.
Yes.
134.
Yes.
The judgment starts at page 134. Kindly have a look at para 5. The district collectors issued summons, they did not go. In our opinion, such cavalier approach and disdainful attitude of district collectors may land them into a difficult situation. When the court has passed an order directing them to appear in response to summons issued by ED, they're expected to obey the said order and remain present before the ED by not following the order. They have created the impression that they do not respect for the court or the law, much less for the Constitution of India. Such an approach is strongly deprecated. However, having regard to the fact that general elections are scheduled in the state of Tamil Nadu, in the learned Senior Council Civil on instruction state, the respondents are collecting data as desired to be furnished in response to summons from the concern. The department will deem it appropriate to give them one more chance to appear before the ED in response issued by summons under Section 50. In view of it, it is directed that respondents shall remain personally present, appear before the ED on 25/4/24. Now, kindly look at the order. The order is passed on 2nd. So they were given time to appear because they were involved in some collection of data, but they were in a different offense, which is the last thing. So the submission is that they can't refuse the summons. They can't challenge the summons in a writ petition. How to investigate, when to call a witness is the prerogative of the investigating officer. They have not even said that they will be arrested if he is busy. As I've said, they can come immediately after the campaigning is over. Even if he comes on the 30th, I have no, let him come on the 30th, because by 30th his campaigning would be over. Even his voting would be over on 29th. Even voting would be over on 29th, let him come on 30th.
This court is of the view, okay, 24, but election in 29. If he will appear on 30th, what harm?
No problem.
After 4th, my lord. 4th result. And you are saying 4th result.
Maybe, result may be. You to appear. Your work is over by 29th, you appear before the court.
I did not know. But after 4th or 5th, when you are publishing the result, people go, my lord.
You cannot choose the date, sir. Otherwise, I will dismiss and I will allow you to appear tomorrow.
Your lordship,
The court is taking sympathy only on because of the 29th is the election date. You are the candidate. So that, okay, you will allow to be continue on 29th and appear before the authority on 30th. That's all. Nothing else. If you want, then I will. Otherwise, if you continue on to that 4th or 5th or 15th, then I have to pass the detailed order rejecting the writ application. Nothing else. What will happen on 30th to appear? 29th is work is election will not affect if
no, I know. That's what you are saying, correct. 30th,
Lords may record that he will appear on 30th and dispose of the petition. Let his statement be recorded as appearing on 30th and dispose of the petition.
Going into the total fact, I will record that, directing to appear before on 30th on completion of that.
My lord, in this matter, my lord, I am appearing on behalf of the Union of India, my lord.
Yes.
With Mr. Chakraborty, my lord, London ASGI, my lord.
Yes.
Lord,
So what is your submission?
Ma'am, the answering respondent, Mr. Raju, has already placed. I'm
Yes.
just only pointing out one thing, since my lord is also taking a lenient view. I'm just pointing out one thing, that in the pleading of the writ petition, there is nothing says that there's nothing demonstrate that this summon prejudice the fairness of electoral process or the candidate's ability to contest. So it cannot be termed as an exceptional reason to delay the summons. But my lord has already expressed my lord's mind. My lord is taking the
Not
lenient
fine.
view.
They are taking the view because already the election
Yes,
is
yes, yes.
within
And
the.
since Mr. Raju has also had no objection, but I'm not in the way.
So Raju, only 30th.
I'm saying that I'm only suggesting that he may come on 30th, provided he agrees and and there's a direction given. And if he doesn't come, may I leave?
Thank
Manoj?
you,
I'm
Mr.
called
Raju.
in on the court.
Raju.
Grateful, grateful.
The petitioner, though, have challenged the summon issued by the Assistant Director KLZO-2 Kolkata Zone-Roman 2 Enforcement Director. But in the alternative, he has prayed either to allow the son of the petitioner to appear before the Enforcement Director in terms of the summon issued by the Enforcement Directorate, or to extend the time for appearance of the petitioner in person till 15th of May 2026. 2026, full stop. The main grievance of the petitioner in the present application that in terms of the order passed by the coordinate bench of this court, the CBI has passed by this court in WPA 9979 of 2022, dated 21st of April 2023, the CBI had initiated a case on 22nd of April 2023 for the offence alleged under section 120B cap /34 /420 /467 /468 /471 /12 /13 within bracket 2 /7 section 471 read with section 12/13 within bracket 2 /7 capital A and section 8 of the Prevention of Corruption Act. Upar IPC aayega, full stop. The counsel appearing for the petition submitted that after the initiation of the FIR, the police has the CBI has conducted search in the house of the petitioner, and some papers and one mobile phone.
Not the Enforcement Director.
This was
Yes.
after the FIR.
Yes.
FIR was enforcement.
No, FIR CID, but CBI first by ED.
37 is the ED. Page 37 is the ED.
Yes, man. Yes.
After the initiation of the FIR, the enforcement director had conducted search in the house of the petitioner, and bunch of document and one iPhone was seized. Subsequently, the house of the petitioner was also searched and inventory was made. On completion of the investigation, CBI has submitted the charge sheet. Charge sheet is submitted. CBI submitted the charge sheet, but the petitioner name was not included. Subsequently, the CBI has again submitted a supplementary charge sheet. In the supplementary charge sheet, also the name of the petitioner is not included. Now, all of a sudden, full stop. Now, all of a sudden, on 2nd April 2026, the Enforcement Directorate has issued a summons to the petitioner to appear before the ED on which date?
4th April
2024, 2026. On receipt of the said summons, petitioner has submitted a request to the Enforcement Directorate informing that the petitioner has been nominated to contest the election in the Bidarnagar Assembly constituency, and he is going to file the nomination on 6th of April 2026, and he prays for time to appear before the authority till 15th of May 2026. After receipt of the reply of the petitioner, the Enforcement Director again issued a notice to the petitioner on 7th of April 2026, requesting the petitioner to appear before the authority on 9th of April 2026. 9th of April 2026, full stop. On 9th of April 2026, again the petitioner has submitted a representation requesting the ED to grant some time to appear before the authority on 15th of May 2025. Again, the enforcement director has issued a notice on 9th of April 2026 requesting the petitioner to appear before the authority on 11th of April 2026. On 11th April 2026, the petitioner has given an authorization along with the power of attorney to his son, namely
Samudra Bose.
Samudra Bose, and requested the enforcement director, the ED authorities to allow the son of the petitioner, being the representative of the petitioner, to appear before the enforcement director in terms of the summon issued to the petitioner. The enforcement directorate has not considered this request made by the petitioner, and again on 21st of April 2026, a summon has been issued to the petitioner directing the petitioner to appear before the authority on 24th of April 2026. Now the petitioner has filed the present application and submit that section 50 subclause 3 provides that the petitioner and the summoning person or the legal representative can appear before the authority, but here in the present case the petitioner has authorized his son to appear as authorized representative of the petitioner, but the enforcement director and the enforcement authorities have not allowed the petitioner to appear as the representative of the petitioner. He submitted that the petitioner has already submitted his nomination and election, and he is contesting the West Bengal Assembly election from Bidarnagar constituency, and the voting date is 29th of April 2026, and as such, she requested the authorities to allow the petitioner to appear before the enforcement director on 15th of May 2026. Full stop. The petitioner has relied upon the judgment in the case of Nalini Chitambram versus Directorate of Enforcement, reported in 2018 SEC Online Madras 14055 and submits that subclause 3 of section 50 states that the persons who receives a summon from the competent authority under the PMLA is bound to attend in person. However, the authorities agents are also permitted to attend the investigation on behalf of the persons against whom such summon is issued. He submits that in the present case, the petitioner has sent his son as a representative, but the authorities are not allowed the son of the petitioner to appear before the authority as representative. The petitioner has further relied upon the judgment in the case of Pankaj Bansal versus Union of India and others, reported in 2024, volume 7, SCC 576, and submits that being a premier investigating agency, charged with onerous responsibility of curbing the disabling economic offense of money laundering in our country, every action of ED in course of such exercise is expected to be transparent, above board, and confirming the pristine standards of fair play in action. I submit that in the present case, though the case has been initiated in the year 2022, subsequently the house as well as the search as well as the restaurant of the petitioner has also been searched, and the CBI has submitted the charge sheet. Now, when the case has been when the ED authorities came to know the petitioner has not submitted the nomination paper, has issued the summons for appear in person. Full stop. The petitioner also relied upon the judgment in the case of Vijay Madanlal Chaudhary and others versus Union of India and others, reported in 2023, volume 12, SCC 1, and submits that the authorities under the 2002 Act cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and the scheduled offense has been committed unless the same is registered with the jurisdictional police or pending inquiry by way of complaint before the competent forum. competent for. Full stop. Though the petitioner has, though the full stop, the learned Mr. Raju ASGI appearing for the Enforcement Directorate submit that the writ petition filed by the petitioner is not maintainable, as the petitioner has challenged the summon issued by the Enforcement Directorate for appearance of the petitioner in person for inquiry, but for investigation. But instead of appearing before the investigating agency, the petitioner has filed the present application. He has relied upon the judgment.
Yeah, yes. Why not is or your judgment?
Relied upon the judgment passed by the Honorable Supreme Court in writ petition within bracket criminal number 109 of 2013, Kirti Sri Mankar versus Union of India and others. Union of India others dated 20th November 2014, wherein the Honorable Supreme Court has held that challenging the summon issued by the Enforcement Director for appearance of the person during inquiry of the investigation is a premature, and the petitioner cannot seek any extraordinary cannot seek any remedy under Article 226 of the Constitution of India. He further relied upon the judgment in the case of C.M. Ravindran versus Union of India, reported in 2020 SCC Online Kerala 7555, and submits that a person issued with the summon is bound to attend in person or through the authorized agent, as the officer issuing the summons direct, and is bound to state the truth upon any subject respecting which he is examined or make a statement, and to produce such document as may be required. Mr. Raju, by referring this judgment, submitted the Enforcement Director has issued the summons to appear before the Enforcement Director for recording the evidence, and if required, this document is to be produced, but the petitioner is avoiding to appear before the authority in terms of the summons. He further relied upon the judgment in the case of Veerbhadra Singh and another versus Veerbhadra Singh and another versus Enforcement Directorate and another, reported in 2017 SCC Online Daily 8930, and submits that the enforcement officers empowered by the PMLA to make investigation into the offences under the said law are not to be equated with the police officer. The law confers upon them requisite power to carry out the investigation and collect evidence. The said powers includes the power of issuance of summons to any persons whose attendance is considered necessary and compelling his attendance, whether give evidence or to produce any record, and to examine him on in terms of section 50 within bracket 2 and 3, or to put any person under arrest. Full stop. Had the learned counsel for the respective parties peruse the materials on record. Though in the present case, though the petitioner has, though prayer A of the present writ application, the petitioner has prayed for recalling setting aside the impugned summon dated 21st of April 2026. But in the alternative, the petitioner has prayed for allowing the son of the petitioner to be present before the authority, being a representative of the petitioner, or the time to be extended to appear before the authority after 15th of May 2026. At the time of hearing, the petitioner submit that he is not pressing prayer A, not pressing the prayer A. Only either the son may be allowed to appear before the Enforcement Directorate as a representative of the petitioner, or the petitioner may be allowed to appear in person after 15th of May 2026. This court, full stop. Consider the submission made by the counsel for the respective parties. This court finds that, full stop, being the situation as the petitioner is not pressing for the quashing of the summon, thus this court can entertain the writ application only to see whether the representative of the petitioner under section 50 within bracket 3 of the PMLA Act be allowed to appear before the ED authority, or the time can be extended to the petitioner to appear before the ED authority. This court find that since 2nd April 2020, first notice 2nd April, na?
Yes, madam.
Since 2nd April 2024, the 2026, ED has issued several notices to the petitioner, and the petitioner has responded to the said notices. It is not the case the petitioner has not responded and avoided to appear before the authority. It is the specific case of the petitioner that the petitioner is contesting the Assembly, West Bengal Assembly election from the Bidharnagar constituency, and he is the election date is on 29th of April 2026. Considering the above, this court finds that the petitioner is having the genuine reason for not appearing before the ED authority, and is continuing requesting the ED authority for extension of time. Considering the above special circumstances for not appearing the petitioner before the ED authority, this court inclined to allow the petitioner inclined to extend the time to appear the petitioner before the ED authority on 30th April 2026 instead of 24th of April 2026.
Can you renew? Well, 30th. First is a Good Friday. Second, can you make it second, my lord?
Why?
Our office is open.
Office is there. Why?
First, my lord.
My lord, Sunday we are working. I closed up at 10 p.m.
Just Sunday. Then go. First, madam.
1st May 2026 at 10:30, Mr. Raju?
Yes.
It's not 10:30?
Yes.
At 10:30 a.m.
Where?
before. It is not your prayer that you make the prayer before.
Yes, sorry.
Then
Sorry, madam.
with the above direction, the repetition is disposed of. Thank you.
Yes, madam.
Grateful, my lord. My lord, I am giving my appearance in the chat box, my lord.
Give-
But Delhi is
Where approval
not chief. That is, I'm sorry, my lord. From Jalpaiguri.
Okay. Yeah, chit. Judgment day.
Yes.
My lord,
That's all.
चलो टाइम नहीं मिला हारना नहीं
Next application. Yes, what application you filed? That's similar.
Well, do you are for the petitioners, my lord, actually, my lord, challenging the notification, my lord, dated 20th April 2026, and subsequent notification is there 21st of April, my lord. But not all the portions of the notification challenge,
Certification
that is at page 14, my lord.
14.
My lord, I'm
Imposition of restriction of motorcycle riding and with rallies during poll day. Poll day 2. Poll day two means
poll day -2. Like the stock market, T+2, you have
Yeah,
-2. 2 days back. I couldn't understand. I had to call them and find out what he is.
That is 29.
No, but it's in force today. So I asked and they explained it's -2.
Poll day 2 onward. That's why just I was talking. Where is the legality? Poll day 2. Poll day 2 you cannot.
No. Yes.
You cannot come with rally.
2 days from 2 days before.
Onwards the polling day for conduct the free and fair, peaceful and violence. So within 48 hours that is stopped, na?
48 hours stopped. 48 hours back, my lord. My lord, that is not free and fair. For the purpose of free and fair elections, we will welcome the notification.
Correct.
But my lord, in order to ensure free, fair, peaceful and violence-free elections 2026, in the and to prevent any form of intimidation and source genuine restrictions on use of motorcycle are hereby imposed with effect from 2 onward. Number we are welcoming.
Yes, no problem.
Second, polling day -2 onward, no riding 6 a.m. except in case of emergency like medical, family function, etc. We have certain objections coupled with next paragraph 3. Polling day 6 a.m. 6 p.m. That is prior to that 6 p.m. to 6 a.m. and now 6 a.m. to 6 p.m. No cycle shall be allowed except in cases of medical emergency, family function, other essential requirements like dropping, picking up school children, etc. Well, these two
No pillion
propositions.
rider to polling 2 onwards, 6 a.m. to 6 p.m. No pillion riding on motorcycle shall be allowed except the medical emergency, family functions, and other essential requirements like dropping, picking of school children. Yes.
Well, next, very next, 4 day. Family motorcycle shall be allowed from 6 a.m. to 6 p.m. for voting purpose
Correct.
and for other essential requirements like medical emergency and family functions. And for no other purpose can we use the motorbike, even single motorbike on that day. And prior to this,
Family pillion riding on motorcycle shall be allowed. So you take any of the family to you with your motorcycle.
yes.
Who will identify is the family?
No, they are checking and who's riding with you.
Yeah, then voting purpose, only for the voting purpose.
And
And for
essential.
other essential requirement like medical emergency, family function.
Family functions.
Yes, then
And now, coupled with three, it imposes the blanket provision, no restriction of motorbike for this back of the polling day polling day. It is a blanket prohibition. But article said that I'm reading, that is section of certain rights regarding freedom of speech, etc. 19 to practice any profession or carry on occupation, trade or business. Well, entire movement has been stopped and on
19(1)(g)
19(1)(g)
to practice
any profession or to carry on any occupation, trade or business. But movement has been restricted. On 21st April, another notification has been issued. Shaptik, what I am giving it. We have made a representation against there too. After that,
it's already implemented.
Yes.
Already implemented.
this is one in that has been. It is just what I am giving. Our copy nahi?
No, it can.
Our copy nahi? What I am reading this? 21st.
Ola, Uber, Zomato, Swiggy, and similar home delivery agency exempted is allowed. Is also given at
96. She has that.
office going riders carrying proper identification. Yes.
Well, it exempted give to service providers such as Ola, Uber, Zomato, Swiggy. Similar home exemption is also given to the office going riders carrying it proper identity cards. Lord, it has been said, Article 19, that to practice any profession or to carry on any occupation, trade or business. Lord, office going for the purpose of office, Lord, the professional person or occupational, I do not know what they mean to say. Lord, but the trade or business that has not been exempted prior to 2 days, they will not carry on. 2 days back on the polling day, trade or business. Because of blanket prohibition has been made through a PMLA, every day can move on. But this is the first argument. But second argument is, for the purpose of free and fair election, they have made cycle riding, bike riding. For any purpose and exemption is there, but no other vehicle has been stopped so far as my knowledge is concerned. Had it been allowed, the bike, the car would be under the same notification. My learned friend would come with my side, and it would be objected to.
No, holiday. I'd celebrate a holiday. It is having a bad time.
But this is the discrimination. Lord, I do not know as to why only the bike riding has been prohibited, not restricted. I am not saying this.
Yes.
The other vehicles has been, this is my argument, my lord, and that is the violation of Article 19, 21 and Article 14 as well, my lord. And this, if they made this modification, modified accordingly, we are, my lord.
I don't trust you, Lordship, time led, only 2-3 things.
Who are you?
I'm the applicant, lad.
Applicant, I will not allow that. This practice I will not allow. File one application, subsequent supplementary adding that I will not allow. Sorry.
On point of law, can we?
PIL.
Sir.
Lord, number one, the reason for this is, Lord, intimidation goes on during polling or Lord, -2 days. Intimidation happens essentially on motorbikes. That is what has been identified because they are fast moving. So the same maybe a group of say 20-25 people on motorbikes move from polling booth to polling booth, intimidating and creating trouble. So it is to prevent this that restrictions on motorbike use have been put. Now and this is going on since 1996. There was an order, initial order of the commission is of 1996. I'll show your lordship, that. Now, my lord, kindly take the notification. I'll show your lordship, there is nothing unreasonable. Lord, please see page 14 of the writ petition. Number 1. Polling day -2 onward, no motorbike rally shall be allowed. There is nothing unreasonable about it. In any case, my lord, there are restrictions. Then number 2, polling day -2 onwards, no motorbike riding from 6 p.m. to 6 a.m. except in case of emergency like medical or family function. My lord, this is the most sensitive period, my lord, where one has to be careful. And it has been seen and we have data to show that maximum incidents, it's because of motorcycles. My lord, they are fast moving and they can move into alleys, etc. So therefore, for the last 2 days at night, it is to prevent these gangs on motorcycles without moving or a lot of people together on say 20 motorcycles that this imposition has been put in. And to ensure that people don't have a problem, medical family function exempted. So that it should not create a problem. This is at night. Then please see number 3. Polling day -2 onwards during the day, 6 a.m. to 6 p.m. No pillion riding on motorcycles, because this is also, my lord, a hallmark of these people, my lord, who disrupt. It's the second person sitting, my lord, pillion riders. They are the ones who are really, my lord, the problem creators. Shall be allowed except medical, family.
Why your authority has not put the emergency?
Emergency is there, my lord. Medical emergency.
Why the total emergency has not been put at election prior to date? If your authority is not able to control the motorcycles and
Yes.
you are passing this type of the order, that means your authorities fail to control and putting the restriction upon the all general public. Very sorry state of affairs. Very sorry state of affairs.
Your authorities, my lord, the election commission
You have
felt that
police authority, motor vehicle authorities, and all these things are there. Why? What they're doing? They're not putting the naka. Why the naka is
also-
there? Then
it is
if
also
the
there.
naka is there, why this restriction? You stop the all vehicle, let the vehicle be remain in the law online.
this is an additional safeguard.
Why that is the same? Can you restrict the parties? Yes.
So that,
You will say the court will annoyed.
no, that,
If the court will put the question, then it will come from the birth that the court is annoying.
no, yesterday, my lord, I
I
said,
see. Why you all senior persons, why you are not advising your authorities not to do like this?
my lord, there is nothing wrong in the notification.
Okay, satisfied.
I will try to satisfy your lordship. Now, my lord,
Motorcycle, so nobody will going on the car with the bomb and all the pistols. Yes. The
Lord, you-
persons will not go with
My lord,
the bomb and the pistols.
it is, my lord, the election commission, which is the authority to see, my lord, that elections are fairly carried out, free from intimidation. In their wisdom, my lord, they have noticed that the problems are arising with these motorbike gangs. To prevent that, this
Show me the
notification-
case, show me the how many cases have been registered against the motorcycle gang for the last 5 years.
For the
Show me
last-
the cases.
for the last 5
Yes,
elections.
many motorcycle gangs have been arrested for making any
will not have to-
destruction of the election. Show me.
I'll have to, my lord, request them to, my lord, give it by 2 p.m. My lord, lordship keeps.
That is the problem. You have not collected anything. Simply, taking the advantage of your constitutional right, constitutional power, whatever the order issued, because the election. Because of the election.
My lord, let's look at it from another.
No, I
angle.
have seen the another aspect also.
No,
That
where
is
is the-
saying,
No, no,
you
the
are
see-
saying that, okay, I am
where is the
I am
prejudice?
total agree with your bike rally, though, yes, bike rally cannot. I am total agree.
Yes,
But the person okay, night also I am agree. 6
Yes.
am no problem.
now
Okay,
from the,
night
from the day.
day, how you can? No,
So
you take with the family.
what, let's see,
Suppose,
Yes.
suppose I am residing alone,
Yes,
I become serious.
yes. So there's no problem.
What no problem?
There's no problem. Please read it with the exemptions. My lord, please see this. Polling day 2 onwards, let's see the day. From 6 a.m. to 6 p.m., no pillion riding on motorcycles shall be allowed except in case of medical emergency, family function, or other essential requirements like, my lord, this is, my lord, like. So any essential requirement is allowed.
Okay.
This is what your lordship said, emergency it's allowed.
Okay.
And then, my lord, further, my lord, please see for what are the further exemptions. Service providers such as Ola, Uber, Zomato, Swiggy, again such as, if you're a service provider, allowed. And office going riders carrying ID cards. So, my lord, any form of office, what is the argument? If I have a business, it's not my office. That's not correct. There is an office, it's not.
If I am having the business, so I will carry, I am,
So that is my office.
I will take our registration certificate with the motorcycle in the
Single person is any. If 2 people are, going, the question is,
that's if I will take the worker,
yes, my lord.
if I will take the worker in my motorcycle, if I will take or my worker is taking with other workers to go down,
If my worker is, my lord, for 2 days.
1 day it's okay, if I can understand. On the
Yes.
following day, I can understand. Though 2 day prior,
This is to ensure that there is no intimidation.
that's why this is also implicate that your state, your authority is a fail.
Milord, so that they don't fail, Milord, this is, Milord.
That's why you are pushing the, putting the.
No, no, Milord,
General public.
No, Milord, to ensure that they don't fail, Milord, these restrictions are being done. Milord, question is that is it such an unreasonable restriction
Yes,
that
I
it
am
violates,
sitting here.
Milord, Article 14 and 21 of the
14 and 15.
21, Milord. Right to move.
Why? What is the reason?
The reason I'm telling you, to see, Milord, that there is no violence. If there is violence,
Any notification of the other state, the same restriction has been put. I will dismiss here.
yes, Milord,
All other states have been put the same restriction.
yes,
Show me.
yes, this is
we have
the petitioner. Yes, Milord,
Show me.
page 158. Kindly, Milord, we just got briefed. That's, Milord, served, it's come from Delhi, Milord.
Delhi has not even received.
Yes, you have served yesterday evening. There is a, Milord, compendium. Page, instruction number 66.
Page 66.
Page 66. Milord, please give me a minute, Milord. Oh, 53. Milord, kindly, Milord, I'm really sorry. Oh, 66. 66.
Dealers motorcycles.
Milord, this is, Milord, what is in vogue.
Since 2000.
Huh?
आगे बोले.
Milord, this is, let me, Milord, this is the model code of I'm sorry, Milord, what is this? Yes. The model code of conduct. Milord, this is a regular menace, which is why this is being done.
24 hours. That's what I'm telling.
So here this time,
Hours. We are 48 hours, 72 hours.
96.
that is 1996. Milord, please see, Milord, at least let the election commission decide whether, Milord, it is necessary or not. We don't have the data.
So if
Milord,
you are
we do not have the data.
how you come, how you
I'm saying, court gives me leave to file an affidavit. I will produce the data. What is
I am staying this, you file the affidavit. I am staying this and you file the affidavit.
No, Milord.
State some press for time to file affidavit to justify the order. You are not asking for that.
Milord, perhaps, Milord, your lordship would hear me for 2 minutes.
I am hearing, so you are again on a.
I am saying that I could
file affidavit.
No, I said that I could
And you are
get it.
showing this notification. What the notification says, 2004, what this, have you heard it, gone through?
Milord, Milord, if you love, Milord, may I try, Milord? Our job is to try. Let us try.
Yes, I am giving them, I am not allowing, I am not dictating you, just try, why this order has
So,
come.
Milord, may I just give your lordship the justification?
2 p.m.
Why 2 days before?
Why 2
Why 2 days before? You are having CCTV camera. You are having all these things. And why these 2 days
Let me come
before?
back to
Yeah, I am hearing
Very
2
well.
PM, I have no time.
Very well, very well. Let us, Milord, let me try my justification. If it doesn't find favor, your lordship will not state. Your lordship has the jurisdiction to do that.
No, I am not with regard to jurisdiction, sir. The authorities should act in the four corners of the law.
Milord, it is our submission that, Milord, let's, Milord, look at it from,
Listen, the 24 hours which you are showing,
Milord, is this, Milord,
they're out. You tell me, yes, it will be applicable 24 hours, I will dismiss the writ petition recording your submission. Why 2 days before?
because the election commission finds it necessary for the purpose of maintaining peace, harmony, safeguard to people's lives, that this restriction is required.
Where is the report that this is creating the problems? Where is the report? before passing an order, you have to take all the precautions. Then you're telling that this is going on. That's why the administration is passing this restriction. Because see, justification. You are also in the panel of the government, several cases. And has to take the decision with regard to some justifications.
Well, I was with under Mr. Dutt, he said he has run away from the panel.
Now he has come.
To avoid this,
Now he has
to avoid this. But we had a good time. I used to call the Advocate General as the captain, and we had a very good time for 5 years. But now, my lord, the point is that, yes, your lordship is right that there must be material, and your lordship is also right that this material must be considered before, my lord, issuance of a notification. Now, with service yesterday, this morning, I am unable to produce the data, my lord, which has prompted the issuance of this notification. That's why I said, no, I wanted to file an affidavit.
Next election is 29.
29.
So it will be effect on 26.
26.
26. Come tomorrow with what are
Yes, yes, my lord, I'll do that. I'll come with everything and try and justify.
We act about something that for the benefit of the Chogi so that he can take instruction. First is whether the election commission can substitute itself for the administration. Because we find the moment the model code of conduct was implemented, where the chief secretary chosen by the state removed, the home secretary chosen by the state removed, all high police officials removed, people of their choice, because you cannot choose anybody as the chief secretary.
That's why the first question this court has put whether this is an emergency.
Right. Therefore, this is not
I will not make any comment.
particular under Article 324 of the Constitution. The election commission has to act in terms of whatever is formulated legislation under Article 327 and 328. The election commission must trace out its source of power from the legislation under 327 and 328. Let them come prepared tomorrow.
Come.
To this effect,
But didn't you,
327, 328.
isn't this issue, I believe from the newspapers and from Instagram, Millard, I saw that they had filed, Millard, a writ petition which got, Millard, no order was passed regarding transfer of these officers.
That is not, no, Mr. Datta is telling that once officers have been transferred and how the 324 can be taken into consideration by passing this order. This is the main submission.
Yes, Millard, I'll restrict myself to motorbikes, Millard.
Correct.
Being completely,
We are not on
Millard, at least clients apart, I am very apolitical.
This court is only
I know
concerned-
that that's political. I am also a political, constitutionally bound, and I'll be not argue.
We have to see the law is to be
Only thing, Millard, if I submit
in accordance with.
yes, only thing is number one, is there any unreasonable restriction on a citizen's right to move about freely or to carry on business by this notification? This is the point I will try to answer. And once I have, Millard, the data which justifies this act, Millard, I am certain, Millard, I will be able to convince your lordship.
Record an order. Second, counsel, the petitioner has filed the affidavit of service, kept in the record. The petitioner has concluded his argument. Learned counsel for the ECI has argued the matter at length, but learned counsel has taken the time, has pressed for time. According to cases at let the matter appear tomorrow at the top.
Grateful to lordship. But I have a request, Millard. Millard, when I said yesterday, don't be annoyed with me. It's from a lawyer to a judge. Because I've appeared for 2 years, 3 years before your lordship. Your lordship has never been annoyed with me. I try not to annoy your lordship.
I am here. If private parties, there is
Yes.
no problem.
Yes.
If the administration is doing like this, either any of the see, Mr. Banerjee has taken so many things from.
No, that is fine. But I am saying, don't be angry on me. Be angry on there's no problem. Don't be angry on me.
Not you.
Yes, then I'm happy.
Seeing
No problem.
all these things,
Yes.
automatically it is coming on.
No, absolutely.
It is coming.
I'll try
It
for
is
my
coming to
best
the mind.
tomorrow.
Do the admission, do the authority, do your work
Yes.
as per the law which provides.
I'll come and justify tomorrow. I'm grateful. Deeply. Poor Millard, my lucky matter because I have a leader. Mr. PCI, I have a leader, Mr. Naidu is not appearing online.
I appear online with my lord's kind permission.
Yes.
Well, kindly come to para 16 of the writ petition. Well, first I wish to show your lordship the provision.
Your lordship, I appear for respondent number 3. We have not been served, your lordship.
Not been served.
Respondent number 3. Who is the
Yes,
respondent number 3?
Your lordship, I am the election
Observer, the observer appointed by the election commission. So I'm asking for his replacement.
And your
So naturally, he's a necessary party. But I'll tell you, lordship, what has happened. Service was affected. Now, my lord,
lordship, we've taken instructions at 10 a.m. today morning. No service over email, WhatsApp, or physical, your lordship.
When is the election? 29?
no, this is not. Yes, my lord.
29.
Election,
This police officer also here also.
yes, for the 29 constituency which is covered under the 20 election held on 29th, he is the observer for those constituencies.
Okay, sir, the copy come tomorrow.
Very good.
Grateful, your lordship.
আরে কি বলছে বোঝো না জজ মানে মেয়া যে is he the constituency where he is the police officer there ওখানে তো election 29th এ হবে so then that's what he's saying we'll come back tomorrow then
Tomorrow, give the
Very good.
copy, take instruction.
Grateful, your lordship.
Very copyটা দা
The petitions directed to South Leonard
I'll give
Council,
you the hearing now otherwise again there'll be
Leonard Council for the respondent number 3 submit that he has not received the copy of the writ application. Full stop. Leonard Council for the petition has served the copy of the writ application along with the documents to the Leonard Council appearing for the petitioner in court today. Let the matter appear tomorrow as second matter.
well kindly record given handed over in court grateful deeply obliged
As second matter.
Next one.
Look, item number 117 was fixed at 12 o'clock today. The only thing is, Lord, I had prayed before.
Let this matters complete, then I will take.
Lord, I was not going to do the matter anyways. Just that the interim order is expiring today, that can be just extended. That's all.
Item number?
117, Manu.
I will take this after this.
Yes,
matter.
yes, very well. Yes, yes.
Yes, item number 5, who is appearing?
But I am appearing, Madam.
Yes.
Mr. Raju and I are for the commissions. And I was thinking that I was lucky this time. I wouldn't be involved in this election thing, but I could not keep myself out from it.
Millets,
That's
if my
why
lord-
last year he was government leader and I was usually for the petitioners.
Millets, if my lords permit, Millets, I also appear for the election commission.
On Monday,
Which one?
not 4, where my lord has said the service has not been made yet.
Yes, tomorrow.
If it can be taken it off.
এই যে,
then
হ্যাঁ আমার কোনো আপত্তি নেই
Tomorrow. Where is the petitioner? If they say for tomorrow, Monday, there is no
He's a
problem.
petitioner.
He is a petitioner. He is a petitioner.
This court is no problem if the both party ready on Monday, but taking the
Monday কি অসুবিধা?
Monday.
My lord, we wanted, my lord,
That's why if you give consent, otherwise already given the date on tomorrow at the second matter. Come tomorrow, we'll see.
আর কয়েকদিন করতে চাইছে কেন করছিস
Yes, next.
মানে this is a challenge to a notification issued by the
Mr. Naidu, you're submitting
Yes,
something?
I am for the election commission, Millets. I'm appearing just to inform your lordships about my presence, Millets.
But this is basically, my lord, the point involved is, my lord, here, my lord, on 18th of April, my lord, there are only 2 annexures, so should be a problem. My lord, kindly comes to page 27, my lord.
Page 27.
Yes, my lord. My lord, on 18th of April 2026, my lord,
27.
page 20, my lord, I'm sorry, my lord, it's my PDF page is 27, sorry, my lord.
20, yes.
My lord, this is from the additional chief electoral officer to the ADG and IG district election officers also. Now, kindly may I just place this? This will inform you that after getting intelligence from different sources and information received from various quarters, a list of, kindly keep note of these words, list of most sensitive booths from the vulnerability point of view has been collated.
Information received from the various quarters, a list of most sensitive
booths
from the vulnerable
vulnerability point of view has been collated.
Well, two things, most sensitive booths
And vulnerability.
vulnerability. Now, my lord, what are they doing there? You are hereby direct on these most sensitive booths. You are hereby directed to depute only Central Reserve Police Force who are specialized in handling various law and order situations across the country and in diverse sensitive environment, including communal environment, to conduct free and fair polls. But I have come before your lordship challenging this finding on three counts. One is, my lord, there cannot be appointment of a CAPF organization, my lord. But may I just give a short background? I'm sure your lordship must be knowing, my lord, there is a CAPF which includes 7 constituents. One of them is CRPF. Now, why CRPF is the only authority which is being asked to go and be a part of this and be deputed only at these most sensitive booths? One, because the manual which they have got, I am on the point it's a violation of the manual. The manual which they have got, the manual says that there will be a mix and match. State police as well as the central organization. On the ground that central organization is unbiased. Now, as today the days of bias and unbiased and transparency have, overshadowed all kinds of thought processes now. Now, the point remains today, the CRPF are being told to be deputed only there, and in what booths? That is, most sensitive booths. My submission would be, in the manual, there is no such provision of most sensitive booths. And this deployment of a CAPF organization in totality at a booth is only limited to a critical polling station, nowhere else. So I say that I do understand Mr. Chaudhary has been regularly making this submission. 324 is complete plenary power, but that does not invoke the points of 356.
But how you will affect?
Well, because
who are you?
Yes, I'm a party who is in the elections.
You are the party means your candidate.
No, he's the political party.
One of the contesting parties.
So therefore, an interest.
Filed by the political party.
Yes. Because the point is very simple. I am on the basis of the manual which they have formulated. I am not going beyond that. When that is done, you must show reasons as to why you are trying to move away from that reason, and specifically because there is also a point made out that where this CAPF can be appointed in totality.
Yes.
You just show the manual. I think that is the only point which I've got. Can you take the manual?
You are giving the manual to the authority also. Good.
You have not read it. I'm not sure. Suddenly he makes instructions for it.
Yes.
I also have it.
Yes.
And I was hearing from behind I have also gone through several elections. I'm sure that she has done from the very beginning. Now it's going to, it's a really a web footing, if we say.
Yes.
I feel very concerned. Now kindly takes the manual. First thing, please takes the first page of the manual.
6 months before.
First page, it's the first page, chapter 1, introduction.
Yes.
And it just takes the second paragraph. This is the manual on force deployment. Force deployment, I'll take your lordship to the second paragraph.
Page.
This is page 1.
Page 1.
English page 1. After the small.
Yes, page 1. Introduction.
Yeah. Kindly see the second paragraph. Force deployment has increasingly become one of the most important aspects of conduct of elections, statutorily safeguarding the polling station and EVMs and creating a conducive ecosystem. And a major component of electoral management for free and fair participation of all the stakeholders on equal platform. In the scheme of force deployment, certain armed police force or CAPF occupies central position. Being not part of the local police force, CAPF is perceived as unbiased. This has led to an unreasonable and intractable demand of CAPF at times. ECI strikes a balance in the use of CAPF, blending it with the available local police force and by complementing it with non-CAPF measures. Now it kindly comes to the process which is at 2.
No, in the scheme of force deployment, Central Armed Force occupies central position, being not part of the local force. No problem. is perceived in unbiased. This has led to the unreasonable and impracticable demand.
Of
Yes.
CAPF at times. DCI strikes a balance in the use of CAPF.
Correct.
But there are two aspects to it. One is that the balance should be maintained because it should not be seen that as if the entire police force of the state is also not conducive for the elections. And CAPF also comes in here. So there's a check and balance basically. Now, Malad kindly comes to page 2, 1.3, the process. This involves a meticulously planned process that begins with a meeting of states, MHA with ECI, where an assessment of total force availability and requirement is assessed both at the state and MHA level. Usually this begins 6 months in advance of expected date of elections. After a thorough assessment and consultation of all stakeholders, force is allocated to state depending upon availability. So, Malad, it has to be assistance to state, not the other way around. So, and Malad kindly also sees upon availability, phases of election and input from the state about vulnerability. So, Malad, vulnerability becomes a very important factor in this. Now, Malad will kindly come to what is the scope of vulnerability. Malad kindly comes to page 38, Malad. The 5.1.
Yes.
Vulnerability mapping. So, Malad, to make it a vulnerable situation or a vulnerable area, Malad, there needs to be a mapping first. This says vulnerability mapping. Malad kindly takes the second paragraph. The exercise of vulnerability mapping in the context of the elections which were undertaken with the objective of clearly identifying in advance such voters or section of voters who are likely to be vulnerable, the persons or other factors causing such vulnerability, and taking adequate corrective action well in advance on the basis of such identification. So therefore, first vulnerability, then corrective measures, and then whatever steps you need to take. Now then, your Lordship will kindly come. Well, it kindly comes to Malad. Yes, Malad kindly comes to Malad page 40. Sorry, Malad page 39, last paragraph onwards.
Yes.
Parameters of vulnerability. So, Malad, this is set out. This is given by them, not by me, Malad. The rules of the game have been set by them. These are the parameters of vulnerability on the basis of which, Malad, these are pre-poll complaints, act of political parties, voting person in the previous elections. Then, Malad, kindly comes, Malad, 5.6 at 41. Appointment of suitable sector officers and their responsibility.
Yes.
The appointment process is to appoint, Malad, when it's a vulnerable situation in areas. First, there will be sector officers, and then, Malad, other steps to be taken by the sector officer in consultation with the district magistrate and special executive magistrate. And this is the responsibility of the sector officer. Malad kindly takes 42. The pre-poll responsible sector officers relating to the vulnerability mapping includes, so Malad, the sector officer will take steps to try and correct the vulnerability if it's a vulnerable area on the basis of, Malad, data collected to reach a conclusion it's a vulnerable area. Then, Malad.
So if you are taking this plea, correct? If the authority will satisfy, yes, they have got all the data.
Absolutely.
Then only they have done what remains.
I'll just show one more page and then I'll make my submissions on that. I'm sorry, Malad, I should answer it, but this will be easier for me to answer, Malad. It kindly comes to page 52. I'm sorry, Malad. First, page 50. Now, Malad, there is a timeline set for this.
Yes.
Timeline for vulnerability mapping. The exercise of vulnerability mapping shall begin 4 months in advance. So district magistrates are fully aware of the situation at the time the same is reviewed by the commission. So first, Malad, there has to be a mapping, then considered by the commission, and And this is the schedule. All laid down are to be completed as per schedule. Now kindly see the schedule, my lord. Collection, compilation, all from 6 months before. And then, my lord, will kindly come. My lord, kindly see serial number 13, my lord. 12. Completion of preventive legitimate action against the persons responsible for causing vulnerability.
Where?
My lord, the next page when it continues in the box, my lord. The timelines which are given, my lord.
Serial number?
This is 12, my lord.
Completion of VM, vulnerable report DO and this and so within 10 days of the.
I'm on the 12, my lord.
Hello.
After these reports are given, my lord, then, my lord, they have to.
Final identification is before issue of custody.
Vulnerability, yes, 7 days
7 days.
before the poll.
Yes. This Mr. Mallet, I need to see 7B,
And A also.
7A and 7B.
They should have come out.
Preliminary identification and submission of vulnerable VM report of vulnerable areas, villages, hamlets, person causing vulnerability 2 months before the date of poll. And next is 7B, final identification of vulnerable areas, segments, villages, persons causing such vulnerabilities after the issue of press note by the commission and before the issue of the gazette notification. That has been in March, Malak. Now, Malak kindly comes.
Is there any definition of the vulnerable? Here?
Short Malak, vulnerable Malak, how it will be vulnerable? Malak, I'll just take you back, lordship back to that Malak. Malak will kindly take 5.5. Parameters of vulnerability. The sector officers will be trained. They will carry out whether it's vulnerable or not on these parameters. Whether there are pre-poll complaints, well, at page 40.
Yes.
Acts of political parties. Voting percentage in the previous elections. And well, we'll also see after that, once the sector officer reports are given, the district election officer will cross-verify the vulnerability report. That's the end part of para 40, page 40, Malad.
Yes. The commission has issued the instruction, yes. During the General Assembly, SDMs will coordinate the orders and assembly constitution within the subdivision. Yes.
So these are the parameters, Malad, which has to be fulfilled. Now, Malad, I'll just take your lordship back to what I was showing, Malad.
Page 51, yes.
It was on page
51.
51, Malad.
7A and B.
Malad, 7A and 7B, your lordship has seen that there is a timeline for this, which is not there because 18th is the notification which I am challenging today. Now, Malad kindly comes to 5.8, which is at page 52. Now, Malad, within this vulnerable, Malad, there is a criticality assessment.
Criticality assessment.
Now, Malad, the second paragraph there, taking due cognizance of the role of muscle power in the elections and taking into account the certain prevailing socio-economic realities of the electoral politics, the Commission has issued instructions to curb the menace of threat and intimidation of voters, especially the weaker section of society at elections by identifying critical polling stations. So, Malad, this is a separate genus, rather a species, if I may say so, where, Malad, it's a threat and intimidation to the weaker sections of the society. And that will be a critical polling station. And the parameters are also given, Malad, the next paragraph, Malad. The parameters are given. And yes. Then, Malad, after the parameters, Malad, kindly sees B, measures to be taken for critical polling stations. Now, Malad, I'll straight away take your lordship, Malad, to Malad, the page 53 starting with reference to polling stations identified as critical polling stations on account of the indicators listed above. One or all of the following measures shall be put in place. All critical polling stations shall have PAPF deployment to safeguard the polling station to the maximum possible extent. So, maximum I'm taking 100%. It is only for the purpose of critical polling stations. Now, in this notification, Lordship has seen that it is not for a critical polling station. most sensitive booth.
Sensitive booth and vulnerability.
Yes. So vulnerability does not allow CAPF in complete extent. So it has to be a critical polling station. They do not say it's a critical polling station. They say it's a most sensitive booth. So that the intention to have both the state police as well as the central police force as a joint measure, that is gone. And for that, they have only placed that within the critical polling stations, nowhere else. So therefore, this has been issued, my submission with regard to this document, this document, first of all, it is an arbitrary action. It does not refer to any vulnerability report. It only talks about that after getting intelligence from different sources and information received from various quarters, I've shown that a report is necessary, and the report annexures are also given by the manual itself. So this is not the way of just appointing.
That's why I'm telling because the report, what report they have collected.
That they can, because I am not entitled to that.
Under what circumstance?
The only thing is, from the face of it, what I'm trying to show today, what I can show is that it is not a critical polling booth. So if it's not a critical polling booth, the direction, only CRPF, who are specialized in handling various laws. I don't know why they had to choose only CRPF from the CAPF organization. That should be randomized. That is the intent behind the forced deployment. But they say only CRPF.
Where is the list? List not in
the list I have not been able to get.
State there's been yes.
And I don't think there's any input from state. We'll have to show that. But I don't know whether the stakeholders have been looked into. What prima facie I'm trying to show, it is contrary to the manual. Now, I expect some kind of legal submissions from, I believe, Mr. Naidu as well as Mr. Chaudhary. May I just make that submission to counter that beforehand? But first thing, as I said, 324. 324 cannot be used as a sword, even in places, where the rule of the game has been set by them. Now, I have been following Mr. Chaudhary's submissions in courts from various judgments. It's also his submission that where there is no provision provided in the rules, then they would use their plenary power. But I am showing from their rules that it is only limited to critical polling station, nowhere else. And there's a timeline within which he has to exercise that.
So you mean to say they can invoke the provisions of 324, but in parameters of the guidelines provided in the...
Yes.
That is simple seat.
Yes, and they cannot... So simple rules, you cannot add to it.
Correct.
That's what I want. And I do appreciate fair elections, the only thing which we are looking for. But there are some parameters which you have set and which we must follow.
Okay.
And they are also required to follow.
Okay.
And holding a place as vulnerable, it's not that easy as identified by them only. They say this report, that report, cross reports, and then only.
The state police and...
Yes, Mr. Naidu.
May it please, minutes. My lords, may kindly see minutes at the very beginning, the writ petition. My lords asked a very pertinent question. Who has come before the court, what the locus is? And they have said, my lords, it's a political party. So be it. My lords could see at page 1, the array of parties.
Yes.
All India Trinamool Congress having its principal office at so-and-so, etc. That's the petitioner.
Correct.
And Millard, that being a corporate entity, if ever, it should be treated as a society. And then Millard's, nobody represents it, is my humble submission. No human element has been added there. First thing. Now, my lords may kindly come to page 19, where a deponent affirms to the facts of the case.
Yes.
Could my lords come to that one, Millards? I so-and-so, self-employed, do hereby solemnly affirm, state as follows. I am the authorized person of the petitioner. He has never said that he is a political functionary or that he has the necessary authority to represent. evidently or presumably, in my humble submission, he
Yes.
must be representing someone else who has authorized him.
Yes.
Who has authorized, that's not been revealed, nor has the authorization been submitted for my lord's perusal.
Yes.
These two things. Now, my lords may kindly come to the complaint that's been lodged with the authorities by the party through a particular person. Could my lords come to page number, that's annexure 21 minutes, annexure P2.
Yes.
At page number, that name for the purpose of name, let's kindly come to page 24. Page 24 minutes, if I'm not troubling. There's the name, member, National Working Committee, the party. Then my lords may kindly see what's been alleged. Could my lords come to page 21 minutes?
Yes.
The very beginning, Millets, the first paragraph, I may read, Millets, with my lord's kind leave. This is to bring to your notice that an official communication dated so-and-so has been issued by the Office of the Chief Electoral Officer, West Bengal, directing that only the Central Reserve Police Force be employed at certain so-called alleged most sensitive booths in the ongoing West Bengal Legislative Assembly elections of 2026. Could my lords come to next page, Millets? I will not trouble your lordships with everything else. Kindly come to page 22. Any selective deployment of a single force, such as an exclusive deployment of CRPF, in identified areas instead of the standard mixed and randomized allocation based on objective security assessment, constitutes a clear departure from the accepted framework of force deployment. The purpose of such randomized deployment is to ensure that no single force develops area-specific familiarity, influence, or perception of alignment. Any deviation from this framework is liable to affect both the reality and perception of neutrality in election security arrangements, which are essential to the conduct of the fair and credible elections. My lords may kindly skip the next paragraph, then come to the other one. Further, the impugned direction appears to curtail the role of the state police at polling stations. As per clause 8.2.6 subclause 3 of the Handbook for Police Officers 2023, issued by the Election Commission of India, the state police is responsible for maintaining general law and order inside and outside polling station premises. Any arrangement that effectively excludes or sidelines the state police from active deployment and supervision at polling stations interferes with the discharge of those statutory functions and encroaches upon the constitutional domain of the state. In the absence of express statutory authority, such an encroachment is constitutionally impermissible. My lords, the last paragraph could see, Millard, the next paragraph rather. The Election Commission's manual on force deployment also requires that deployment be undertaken on the basis of a careful and comprehensive assessment. I may crave your lordship's attention to next page, page 23. The applicable framework, my lords could see that one?
Yes, yes.
The applicable framework requires that intelligence inputs relating to electoral security be shared with state authorities to enable coordinated planning and effective deployment. In the present case, there's nothing to indicate that the alleged inputs forming the basis of the impugned action were ever communicated to the state. Such non-disclosure undermines coordinated security arrangements, impairs informed decision-making, and reinforces the apprehension that the exercise is opaque, unilateral, and contrary to established procedures and principles, so and so. Now, my lords may kindly appreciate one preliminary factor that I may say that the election process has been on for a while, and today is one phase of election. At this stage, Millers, they wanted, if at all it merits your lordship's attention, that the forces must be changed, or that it should not be one homogeneous force, it should be mix and match of many components. This is what they have said. And though that application, rather that representation does not speak eloquently on why they wanted, kindly come to Millet's page 5 of the writ petition.
Yes.
Could my lord see Millet's para 8?
Yes.
It is an admitted position that the petitioner is the main opponent to the Bharatiya Janata Party, which party is admittedly in control of the central government. It's obvious and well known that the CRPF is directly under control of the central government and is likely to be susceptible to the suggestion and control of persons in the BJP. Therefore, the impugn notification does not instill any confidence in the conduct of free and impartial elections. My lords may kindly appreciate one factor here, my lords, before I go further. The Election Commission of India, a constitutional body, is headed by a Chief Election Commissioner of India. And he cannot be removed other than by impeachment in Parliament. And this is the protection that's been given only to a few constitutional functionaries. For example, your lordships, the judges of the Honorable High Courts and the judges of the Honorable Supreme Court, the Election Commission, Comptroller and Auditor General. These are the ones who are supposed to be absolutely fearless and neutral. They cannot have any political allegiance.
Correct.
Here, Millet's, first, with great respect to the petitioner, whoever has drafted it, it's a disservice to the CRPF, which works in the most hostile circumstances across this country to protect us. Saying that one, the whole force at large would be listening to a particular political party. Though Millet's, as representing, or the Election Commission itself, cannot make any political observations or speeches because we have been sworn to neutrality. But this logic applied on the converse, somebody else could as well say, if that force is in the control of, allegedly, a central government, and they may listen to them, the state force may also have the same ramification getting faced. It's a self-defeating argument in my humble submission, apart from being disservice to a noble service. Then, my lords may kindly see, before getting or taking your lordships to the manual and the nuances and the material we have relied on, I may also have to say that, Millet's, many people may have many shades of grievances when it comes to elections. It's not possible that everybody is very happy until the elections have been declared so that the losing party could cry. But in between, there could be many hurdles. They have been contemplated and visualized by the constitution makers. And Millet's, they have kept 329, Article 329 in place. Once the process has begun, and Millet's, if it has the impact of in any manner retarding or disturbing that process, and no court may entertain any sort of petition, including under Article 226. That's what 329B would say that, Millet's. Then, Millet's, the imminence of elections, half it is over today, and the remaining half is there. If any such process is there to be deployed in a homogeneous manner as they put to draw and everything, would it be humanly possible, even for the Election Commission, to pay heed to that one? A practical difficulty, essentially it has to be deferred and postponed. Millet's, on this count, before I do take, Millet's, your lordships to the merits of the matter, I'll meet every submission made by them, not shying away. But before that, Millet's, may I raise a preliminary objection, as I've already submitted, with regard to the very maintainability of the writ petition. Once the election process has begun, and Millet's, the question of this nature that's been raised by your lordships, could it come into the dragnet of Article 329B? This is my submission. Could my lords, my colleague will hand over a compilation of the judgments and the preliminary issue, Millet's. I'll come to the merits a little later. Could my lords have a look at the compilation, Millet's?
Yes.
my lords, page A, my lords could see that's been named page A. Judicial precedents on Article 329B of the Constitution. Just there is an extract for that limited purpose. I would like to draw your lordship's attention. Article 329B of the Constitution of India, bar to interference by courts in electoral matters. Notwithstanding anything in this Constitution, no election to either House of Parliament or to the House or either House of the legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. And Miller's essentially no election could be called into question, then the phrase that needs to be judicially interpreted was, is, and has been always is what is meant by election, when it starts and when it ends, and in between, what really constitutes an election. What steps perhaps? Could my lords come to Miller's, the very first judgment, that's N.P. Ponnuswamy. It begins at page 1, Miller's.
Yes.
Could my lord see Miller's?
Yes.
1952, 1 SEC, 94.
Yes.
In this 1 Miller's, kindly come to para 10 Miller's. It is running page 5.
Yes.
As we have seen, the most important question for determination is the meaning to be given to the word election in Article 329B. That word has, by long usage in connection with the process of selection of proper representatives in democratic institutions, acquired both a wide and a narrow meaning. In the narrow sense, it's used to mean the final selection of a candidate, which may embrace the result of the poll when there is polling, or a particular candidate being returned unopposed when there's no poll. In the wide sense, the word is used to connote the entire process culminating in a candidate being declared elected. Could my lords come to Miller's page 12? Para 12 at page 6, the very next page.
Yes.
Para 12. It seems to me that the word election has been used in part 15 of the Constitution in the wide sense. That is to say, to connote the entire procedure to be gone through to return a candidate to the legislature. The use of the expression conduct of elections in Article 324 specifically points to the wide meaning, and that meaning can also be read consistently into the other provisions which occur in Part 15, including Article 329B. That the word election bears this wide meaning whenever we talk of elections in a democratic country is borne out by the fact that in most of the books on the subject, and in several cases, the dealing with the matter, one of the questions mooted is when the election begins. Miller's, then their lordships quote Miller's, Halsbury Laws of England,
yes.
Part 13. Although the first formal step in every election is the issue of the writ, the election is considered for some purposes to begin at an earlier date. It is a question of fact in each case when an election begins in such a way as to make the parties concerned responsible for breaches of election law, the test being whether the contest is reasonably imminent. Neither the issue of the writ nor the publication of the notice of election can be looked to as fixing the date when an election begins from this point of view. Nor again does the nomination day afford any criterion. The election will usually begin at least earlier than the issue of the writ. That means Miller's notification, in my humble submission. The question when the election begins must be carefully distinguished from that as to when the conduct and management of an election may be set to begin. Again, the question as to when a particular person commences to be a candidate is a question to be considered in each case. The discussion in this passage makes it clear that the word election can be and has been appropriately used with reference to the entire process, which consists of several stages and embraces many steps, some of which may have an important bearing on the result of the process. This, my lords have said, Millets, their lordships have propounded the theory of the doctrine of imminence.
Correct.
Once, even before the notification, it appears imminent. For example, Millets, the SIR, which your lordships may have been a witness to, Millets, that has begun much before the notification. It's a process where Your Lordships, the Honorable High Court of Calcutta has supervised and the Honorable Supreme Court has supervised. These are the processes which are antecedent to that one, but still they're in the dragnet of 329. Now let me come to the other judgment where this point has been taken further and articulated. Could my lords come to minutes 17, page number 17, perhaps the most oft-cited judgment, Mahinder Singh Gill's case minutes.
Yes.
Page number 17.
Yes.
Could my lords come to minutes? Page 64 straight away. It's the longest judgment. Page 64 minutes.
Yes.
Could my lords come to para 92 minutes?
Yes.
Diffusion, even more elaborate discussion, tends to blur the precision of the conclusion in a judgment, and so it's meet and we synopsize the formulations. Of course, the condensed statement we make is for convenience, not for exclusion of the relevance or attenuation of the binding impact of the detailed argumentation. For this limited purpose, we set down our holdings. My lords, by now may have realized, my lords, it is by Honorable Justice Krishna Iyer, so I have to struggle a little bit to read this one, given the phraseology his lordship employs. And Millets, it's inevitable every honorable judge across India first comes under his influence when he begins his first judgment.
When the judgment is coming with the touching, then you have to read again and again.
Yes, Millets. Yes, Millets. And every judge, once gets onto the bench, Millets, he tries to, with great respect, imitate Krishna Iyer when it comes to judgments. Then everybody realizes it's almost impossible. Then they go to their own styles. May I read, Millets? 1A. Article 329B is a blanket ban on litigative challenges to electoral steps taken by the Election Commission and its officers for carrying forward the process of election to its culmination in the formal declaration of the results. Election in this context has a very wide connotation, commencing from the presidential notification calling upon the electorate to elect and culminating in the final declaration of the tenure returned candidate. The Constitution contemplates a free and fair election and vests comprehensive responsibilities of superintendence, direction, and control of the conduct of elections in the Election Commission. This responsibility may cover powers, duties, and functions of many sorts, administrative or other, depending on the circumstances. Now, my lords may kindly come to minutes, page 69.
Yes.
Para 120, sorry, the 107 minutes.
Yes.
I may be permitted to read from the 6th line, minutes, to save your lordship's time.
Yes, no problem.
The penultimate article in the chapter, my lords got it?
Yes, yes, got it.
The penultimate article in the chapter, as it stands, is Article 329, which puts a ban on interference by courts in electoral matters. We are not concerned in this appeal with the newly added Article 329A, which is the last article to close the chapter. Para 108. Elections supply the vis-a-vis to a democracy. It was, therefore, deliberately and advisedly thought to be of paramount importance that the high and independent office of the Election Commission should be created under the Constitution to be in complete charge of the entire electoral process, commencing with the issue of the notification by the President to the final declaration of the result. We are not concerned with the other duties of the Election Commission in this appeal. My lords, the gravamen of the judgment, Millets, it's been initially at the very beginning summarized at para 92 Millets, that the process includes beginning from the notification till the declaration of the results, and to that entire process, 329B applies, is what the Constitution bench has held, Millets. In support of that, may I take your lordships to Millets, page 79.
Yes.
79 Millets. This is another Constitution bench decision, Millets. This is 1954 2 SCC 20, Durga Shankar Mehta versus Thakur Raghuraj Singh and others. Straight away, Millets, kindly come to Millets, page number 87.
Yes.
Millets, my lords could see para 8. The bottom para is para 8 Millets.
Yes.
About that, 7th line, Millets, placitum E. My lords could see on the right side placitum E.
Yes. It was.
It was indeed, Millets, I'm grateful. It was held that the word election in Article 329B of the Constitution had been used in the wide sense to connote the entire process, culminating in the candidates being declared elected, and the scheme of Part 15 of the Constitution was that all matters which had the effect of vitiating election should be brought upon only after the election was over and by way of an election petition. The particular point which arises for consideration there was not decided, here was not decided in that case and was expressly left open. To just underline, Millets, my submission that the process, how it includes, and my final judgment, Millets, I will not trouble you lordships beyond this one. Kindly come to page number 91.
But you can address one thing if with regard to okay, it is election and all these things. With regard to the administrative decision, what would happen?
Yes, Millets.
Administrative decision during the election process.
Millets.
Administrative decision as like this decision.
Yes,
so what happened to that?
Precisely, Millets. Millets, this process has begun sometime. And Millets, then the whole exercise has been on. And now, yesterday they come before your lordships. And the representation was on 18. Not even any time to consider if there is any element of truth in it. The very next day or in 24 hours, they come before your lordships. And they say that Election Commission has violated and the federal spirit has been defeated. All these things have been made, Millets. My only submission could be, Millets, is it a bona fide writ petition that really craves a precious judicial time of your lordships in this sense? This being the case, Millets, only thing that, Millets, I've said I'm not reading. This one, with reference to the paragraphs, I stop, Millets. Page 91. Millets, this is a 3-judge bench decision. Millets, paras 31 and 32. Millets, in a sense, this judgment has encapsulated all the other judgments I've read up to now. I've said, Millets,
yes.
Page 107, I beg your lordship's pardon.
Got it, got it.
I just forgot to mention that one, Millets, I may be pardoned.
Yes.
Now, Millets, I am tasked with answering on the merits as well. Millets, at page 21, I've taken your lordships to their representation and the allegation or whatever insinuation. Now, the question is, Millets, why only CRPF? Let me assume, Millets, I put some other force in charge, then the question could be, Millets, why only that particular force? It goes endlessly. Once you have any so-called trust deficit, Millets, anything, and more so, Millets, before making an allegation, the petitioner may have looked at whether the Election Commission could be made into a controversy of some political party which has nothing to do with the process that I undertake, that of conducting elections. First thing, Millets. Now, they have made a heavy reliance on the manuals of the Election Commission. They say that we have set the rules of the game and we should not be violating. For that purpose, Millets, let me take your lordships to some of the provisions, Millets, which they've been harping on. Could my lords come to, Millets, page number, where's the combination of CAF?
65, page 56.
Yeah. Could my lords come to, Millets, page number 56, Millets?
Yes.
Just to say the composition of CAPF, Millets. Millets, could my lord see page 56 of the manual, which could be given? One moment, Millets. The manual. Would my lords have the manual, Millets?
Yes, 56.
I'm grateful, Millets. 56 of the manual. Identification of forces. Could my lord see that one? B.
Yes, Lord.
Point
yes,
B.
Yes.
The CAPF broadly consists of the following forces under the control of MHA.
Yes.
Assam Rifles, Border Security Force, Central Industrial Security Force, Central Reserve Police Force, Indo-Tibetan Border Police, National Security Guard, then millets, Sahasra Seema Bal, any other forces detailed by MHA, residuary 1. And millets, D is Central Reserve Police. In my humble submission, this is CAPF. We draw battalions from them and we deploy them. Once millets at one place, we cannot take one person from A, one person from B, one person from Z. It is a security operation. There need to be a coordination. Millets, even when I make my submissions, millets, I need to coordinate with my colleague in front of your lordships. Unless we have that wavelength and repo, it is almost impossible. If I have somebody picked up all of a sudden and say that you also be there, it is a logistical problem. And millets, if at all, their logic that they are under the control of a particular political party, whatever is correct, the rest are also the same. It goes without saying, the same allegation. This is one problem, millets, we face. Because it is security operation which is very sensitive. And one group of people may have been trained in a particular manner and they do coordinate well. This is the submission, millets. Only I am saying these are the compositions.
Yes.
This is
Now-
one thing, millets.
Now, kindly come to the page 20, which is under challenge.
Yes, I am coming to that straight away. My lords could see page 20 of the manual.
Correct.
Yeah, I'm coming, millets. I'm grateful for leading to that straight away a point, millets, so that I could answer. Millets, yes, I'm at 20 millets.
Yes, 20. So, various quarters of the list of most sensitive booths and vulnerability.
Yes.
So now they have pointed out from the manual. So
Yes,
how this sensitive booth is not there with
Yes.
regard to there is another provision on that. What is
Critical
that?
polling station.
Critical
Critical
police.
polling station.
Critical
Yes,
police.
Yes,
Police station and vulnerability, and there are procedures
Yes,
which main argument made by the petitioner that the procedure which has been provided in the manual that has not been taken care of it and the order was passed. This is simply stated what the
Yes,
this will understand the argument made by the petitioner.
Absolutely, millets. My lords could come to straight away page number 66.
Yes.
66 millets.
Got it.
The state police, could my lord see?
Yes.
Area domination,
Yes.
the responsibility of theirs, millets. At the previous page, perhaps, millets, that will throw more light. Kindly come to page number 65. Stages of force deployment.
Yes.
Stages of force deployment. G, millets, just below the table.
Yes, got it.
Yes, millets. Pre-poll day deployment, CAPF. CAPF arrives in advance to carry out flag marches for area domination, point patrolling, and other confidence building measures till 2 days before the polling day. So they
Yes.
need to be there. They do all these things. Coordinate with, I beg your pardon. Coordinate with local police under the guidance of DEO, SP, provided with area-wise list of antisocial elements, list of vulnerable hamlets, and critical polling stations. My lords could see that, millets?
Yes, got it.
Then, my lords, point 3. Necessary teams are constituted to take out flag marches, point patrolling, sanitation, particularly of LW areas, and other confidence building activities, including interaction with local population of vulnerable hamlets, mostly on foot. My lords may kindly come to the next point, the next page, 66. May also be used for additional deployment on checkposts for preventing illegal movements of cash, liquor, drugs, and unaccounted election material by political parties' candidates. Now kindly see the role of the state police, millets, because the petitioner perhaps hops on that aspect. I will address. Area domination in case of inadequate CAPF. Millets, my lords could see. Only when there is inadequacy of CAPF, they should be populated. They should be populating a particular area.
Yes,
so that they could discharge their functions. The second one, guarding of EVM strong rooms and EVM warehouses.
Yes.
Vulnerability mapping and take preventive measures. This is where they were pointing out it should have been the state authorities that should be, or the police authority, they should be doing this one. Where is that material?
Correct.
Millets, I assure your lordships, Millets, Election Commission of India never acts in a knee-jerk reaction manner, because Millets, it is not one particular state it conducts elections. It does across the country, and in everywhere, Millets, it follows the identical process, and it gets the inputs that could be in the past, that could be in the context of this election. My lords may kindly see, everybody should be wiser with experience. A particular state, it could be any state, but since we are dealing with a particular state, Millets, say West Bengal Millets, my lords could recollect in 2021, there were elections. After that, a lot of violence and 81 lives lost. And the Human Rights Commission, NHRC, sumoto took cognizance, visited, submitted a report, and then the Honorable Supreme Court has taken cognizance, and thereafterwards an inquiry was conducted, and then everything is matter of history, Millets. So, for example, once there is a history of violence and it's been borne out by the record, I don't need to reinvent the wheel once again and say that this time also you supply the information. If there is any new emerging trends, say for example, Millets, 10 areas last time we had better experience, then this time maybe 12 areas could be added by way of inputs. And my lords have seen who has been spared in this melee of one-upmanship, whichever way, whichever is the political party, Millets. Even recently in SIR, when the Honorable Court exercising Article 142 deployed the judicial officers, even they have not been spared. And my lords, something has gone viral, which must have been witnessed by your lordships, as the Honorable Supreme Court did. It was displayed there in the court. A district judge ranked woman judge crying in the van, please, they are killing us. If anything happens, save my children. So these are the areas who have been concerned. And when it comes to violence, your lordships have held that zero tolerance must be the one. It's better be safe rather than to err on the right side, on the safer side, than take chances and wait and then book a crime. So all these things cumulatively have happened. That's why vulnerability mapping and take preventive measures, implementation of model code of conduct, establish check posts, etc., etc. 6, responsible for maintenance of the general law and order. 7, implement election expenditure monitoring guidelines. 8, handle VIP movement. 9, implement deployment plan. 10, provide logistical support to CAPF. Again, it has to provide logistical support. Now, my lords may kindly see the role of CAPF. Poll day and post-poll deployment. Guarding the polling stations, EVM, etc., etc. Static guarding of trouble spots, my lords could see.
Yes.
This has been especially mandated.
Yes.
Static guarding of trouble spots. Patrolling duty on assigned routes covering a fixed cluster of polling stations. Patrolling duty as flying squads in a demand area with surprise element. Strong room security after poll.
Yes.
These are the ones, Millets. Now, my lords may kindly see what is the duty of the state police. That's also been specified. The next one, could my lord see? Maintenance of the general law and order in the catchment area of the polling stations and inside and outside of the polling stations as different police from polling stations. Ensure safety of voters, polling personnel and polling material. Continue implementation of model code of conduct. Continue implementation of election expenditure monitoring guidelines. Polled EVM strong room, etc. EVM strong rooms, etc., etc. My lords could see, Millets, the role that's been assigned is much lighter.
Yes.
And when it comes to the critical areas, the security, vulnerable areas, all these things have been given the task of central forces, Millets, that my lords could see. And Millets, they've also said, when it comes to the blending part, could my lords come to Millets page 1? The introduction part, which has been read by my learned friend for the petitioner.
Yes.
Could my lord see Miller's second paragraph? We may read the same paragraph, Millets, as my lords with your lordship's experience could appreciate that fact, we tend to put our own spin, though the paragraphs, the words may never change. Ultimately, neutrally, your lordships interpret because it's a dispassionate way of deciding. That's why, my lords, I always tell your lordships sit a bit higher so that your lordships could see both. But we see only one side of the coin. May I say that, my lords? Para 2, my lords could see. Forced deployment has increasingly become one of the most important aspects of conduct of elections. Statutorily, safeguarding the polling station and EVMs, VVPATS, and creating a conducive ecosystem has been a major component of electoral management for free and fair participation of all the stakeholders on equal platform. In the scheme of force deployment, Central Armed Forces Force, CAPF, occupies central position. Being not part of the local police force, CAPF is perceived as unbiased. This has led to unreasonable and impractical demand of CAPF at times. ECI strikes a balance in the use of CAPF, blending it with the available local police force and by complementing it with non-CAPF measures. My lords, may kindly say, my lords, here it's been said the primordial, rather preference could be for the central forces because of their perceived neutrality. But it's almost impossible for Election Commission to have exclusively forces only from CAPF.
Yes.
Then, my lords, we have been drafting in the state police as well.
Okay.
And, my lords, they have been assigned tasks which have not been given to CAPF. My lords could see, blending with the available local police force by complementing it with non-CAPF measures. If it's a CAPF measure, local police have no role to play.
Correct.
That's why, my lords, the very second paragraph which they have answered, but rather read, gives the answer to their own question, is my humble submission. So that way, my lords, something, my lords.
Next.
Yes, my lords. Then, my lords, they have also pointed out page 39.
Parameters.
Yes, my lords. Before that, my lords, we have at page number 38, chapter 5, vulnerability mapping.
Yes.
Para 5.1, my lords.
Yes.
Vulnerability in the context of elections is defined as the susceptibility of any voter or section of voters to being wrongfully prevented from or influenced upon in relation to the exercise of his right to vote. This is what the definition of part, my lords. That's how the vulnerable, but it does not mean that, but essentially violence. Vulnerability could have many shades, is my humble submission.
Correct.
Then, my lords could come to page number 39. Every DEO, could my lords see, my lords, 5.5?
Yes.
Parameters of vulnerability. Every DEO needs to collect input based on present and past records. This is what I've been emphasizing, my lords. No state goes to the elections for the first time, as we call in the judicial terms, res integra, completely unopened. It's an open experience. We have had many times witnessed them in many states. So, my lords, it's the cumulative wisdom of the Election Commission that compels it to take certain decisions. And here, my lords could see, it is based on the present records and the past records. Once those records are available, my lords, it doesn't lie in the mouth of anybody that there has been anything called mischief. Now, my lords, may kindly come to, my lords, page 41. Could my lords come to, my lords, 5.6. Action to be taken for vulnerability mapping. This is how the vulnerability mapping happens. And, my lords, the first part, my lords, have already read, either based on the past experience or the records and the present inputs.
Correct.
So, my lords, it is a continuous process, always getting complemented, and accretion of information is inevitable. Then, my lords, may kindly come to, my lords, page 44.
Yes.
Millards, that para D, my lords could see. Identification of vulnerable areas, segments, villages, hamlets.
Yes.
And this is how, Millards, we did follow the whole process based on the data that's been made available to us, and then we have taken a decision. Then, Millards, their point is with regard to timeline.
Yes.
Could my lords come to Millards page number 50?
Page
50, Millards.
50. Yes. Timeline.
Timeline for vulnerability mapping, Millards. Could
Correct.
my lords say the very first one in the table, collection and compilation of basic information on each AC by DO as per annexure 1, etc. 6 months before. It happened 6 months before, Millards. Then every step my lords could see with a time frame. Then eventually my lords could see 12. Because
Yes.
all of them, Millards, there's a time frame.
7 days before the yes.
Completion of preventive legitimate action against the persons responsible for using vulnerability. I've already submitted to your lordship's kind consideration. Vulnerability may also include influencing the voters.
Correct.
So all checks and measures must be there, Millards, in the process of election. This is the only thing as common man on the street, in the names of R.K. Lakshman's common man, Millards, only thing the common man has to put any politician of any stature on the mat. And that right cannot be bypassed. And nobody allowed to steal it. And I am the sentinel, I am the watchdog, if I could use the expression, the election commission.
Okay. Next.
Millards, my lords could see, Millards, at least 7 days before that. Then Millards, 14 my lords could see. 14 in that one. Pre-poll area domination by CAPF.
3-5 days. 3 to 5 days before the poll day.
Yes, Millards. My lords have seen that, Millards. Then my lords could see 15. Strict vigil and monitoring of vulnerable areas, persons by observers, DEO, RO, SO, and police.
That is normal, yes.
Absolutely, Millards. That's normal. They can't make a mountain out of that one.
Correct.
A molehill. Now, finally, Millards, could my lords come to page number 67?
Yes.
Could my lords see, Millards? I may be repeating, Millards. Kindly come to the page number 67, activity part.
Activity and timeline.
Yes, Millards, indeed. I'm grateful for correction, Millards.
Yes.
Preliminary vulnerability mapping and identification of critical PS analysis 6 months before the date, and that's to be supplied by DEO or SP. Millards, on instructions, I do submit, Millards. We have had the material, the inputs, the intelligence based on the past demographic distribution of the elections and the violence pattern and the present inputs. And then, Millards, we have done that, Millards. Their grievance is that one, that only CRPF, it is part of CAPF, Millards. And then, Millards, for the homogeneity, for the operational ease, we do that one, Millards. There are no malefides imputed to us to negative or negate an administrative measure we have taken under the statutory provision, the constitutional provision, and also our own manuals. I do respectfully submit, Millards, that in the first place, this is a misconceived writ petition. There is no locus for someone to espouse the cause of a person who has never been authorized. Second thing, Millards. And the third thing, Millards, as per the scheme and all these things, Millards, we have just followed the process to a perfection, and our only endeavor is that, Millards, to ensure that the elections are free, fair, and the people are safe.
Correct.
Because we cannot regret later, Millards.
Yes.
I'm grateful for the opportunity.
Thank
2 minutes,
thank
Millards. Only 2 minutes in reply, Millards. Very quickly, Millards. Millards will kindly take the, sorry, Millards.
Yes, yes.
I thought your lordship is, Millards, kindly takes page 107 of the compilation, Millards. And I'm showing his judgment only, Millards. What fell from your lordship, Millards? What about the administrative part? Millards, that has already been settled, and it is his judgment which I'm showing, Millards. Kindly takes this judgment of 2008, the Election Commission of India versus Ashok Kumar.
Yes.
Millards, para 31. The founding fathers of the Constitution have consciously employed use of the words "no election shall be called in question," the body of Section 329B. And these words provide the determinative test for attracting the applicability of 329B. If the petition brings the court calls in question election, the bar of Article 329B is attracted, else it is not. So, my lord, I am not challenging the result of the election. And my lord, this is what I also, my lord, in a very recent judgment, my lord, your lordship is well aware, the Jammu and Kashmir and the Ladakh Union Territory, my lord, there also, my lord, after considering, do you have another page?
This is yours.
This is ours? Okay, sorry. Find that up. Okay. Which page?
Considers a judgment.
Para 36, page 40, man. Kind comes to page 40, man.
Large number of the judgments are considered.
Most of the judges which my learned friend has relied upon considered, and para 37. Para 37 runs into page 42, Malat. But where issues crop up indicating unjust executive action or an attempt to disturb a level playing field between candidates and a political party.
47.
Para 37, running into page 42, Malat.
Correct.
But I'm trying to hurry up because when I find someone, please Daniel options.
Yes, which paragraph?
That paragraph 37, but starts from the person, but where issues crop up indicating unjust executive action. At this point of time, the executive action is with the ECI.
Yes.
Or an attempt to destroy a level playing field or under political parties on non-justifiable, intelligible basis.
Yes.
The constitutional courts are required and nay, they are duty bound to step. This is where I'm coming in, Malat. But the main question which I raised was, Malat, there is no,
Yes, continue.
But there is no provision for most sensitive booths for which total CRPF. And I've shown their rules provide only in critical polling stations. Well, now my learned friend can come and say, I've done everything. But I cannot justify that. He has to justify that. I don't find it because, Malat, the wordings of page 20, Malat, only says I've proceed on the basis of intelligence and sources. But only last, Malat, kindly comes to page 5.5, page 37, Malat, of the manual, Malat. But my learned friend was showing a lot of things about who were in control of what and what they have to do. I do appreciate that. It is obvious. But Malat will kindly come to clause 5.5.
Page?
This will be page
5.5. Yeah, parameters.
Parameters, Malat.
Yes.
39.
Page 39, yes.
Yes, parameters, page 39.
And kindly sees
based on the inputs
and at the starting, because my learned friend says history of violence, future of violence, that is good enough. Malat, at every instance they are supposed to provide for Malat sees VM-1, annexure 1, a set of parameters to collect the input on vulnerability. This has to be separately done. My learned friend and the Election Commission is referring to earlier post-poll violence for the purpose of defending this case, Malat, that itself shows, Malat, why this apprehension. And lastly, Malat, with regard to my locus, Malat, the affidavit of competence is there, Malat. Mr.
But what is the cost title?
Malat, that can be under the Representation of People's Act, Malat, section 29B. No. Malat, that is registered under the Representation of People's Act. Any association or body of individuals.
Section?
But 29A, I am registered under this, Malat.
Yes.
This is not a registration under the society's registration. This is under this act. And it has its own committee, Malat, the working committee member has authorized this person, Malat, and that is in your Malat affidavit of competence. It is there.
Okay.
So, Malat, that may not be correct. And last, Malat.
Yes.
If I have violence, history, violence, those are my subjects.
Suspect time.
And Malat, he pointed out Why am I coming on the 21st? Well, the notification is for 18th. When do I come before your lordship?
Okay.
And we've made the complaint on 19th, and we've come before your lordship.
What can be done?
They should have done it.
My lordship, yes, let my friend finish, Millets. I'm not coming.
Yes, I've finished.
Yes.
Millets, my lords have given me a great indulgence. I don't want to overdraw on your lordship's kindness, but my friend has pointed out my own judgment will be useful for him, Millets. Kindly have a look at it, Millets. Just judgment. What's been said there, Millets, after in the same para 32, my lords could see. Millets, my lords may have realized by now, the judgments are the most dangerous thing. They speak in many tongues. President is always unfaithful.
Page.
Page 107.
107 Millets.
Yes.
Millets, para 32, my lords could see. Para 32 Millets. In that one, subparagraph 3, my lords could see. Subparagraph 3. Subject to the above, the action taken or orders issued by Election Commission are open to judicial review on the well-settled parameters which enable judicial review of decisions of statutory bodies, such as on a case of malafidis or arbitrary exercise of power. And incidentally, Millets, in this case, even with regard to deployment, there is a joint coordinating committee and the police officials are part of it. The state police nodal officer is also part of the decision-making process.
Okay.
It's not that somebody superimposes any idea or any condition. That
Yes.
my lords could see, Millets, at page 61 of my manual.
But that is my complaint.
58 and 61. I'm grateful, Millets.
Thank you.
This notification has just been sent for information to coordinator.
The Naidu has shown 3, and it also keeps note of 2 and 3, both.
Secret.
And I will not add, it is going on forever.
Thank you.
Very grateful, Malad.
Deeply obliged, Millets, for the opportunity.
140. 2 बजे मैडम ठीक है रुको देखते टाइम मिलेगा हम डिक्टेशन देगा हियरिंग कंक्लूडेड है डिक्टेशन
Malad, item 118 was fixed at 1 o'clock. Lordship may take it up on Monday. Malad, Lordship has to rise now. Lordship may take it up on Monday.
My lord.
Item
Monday at 1, Malad.
12 o'clock
Malad,
fixed matter.
Yes.
Monday 118 के दादा बोलो Monday बोलो 118
আমি তোকে তাই বললাম
और कितना है 2 PM छोड़ा, इसमें कंप्लीट हो गया, लीव मैटर कंप्लीट हो गया। दो लीव मैटर कॉल करो, लीव मैटर कॉल करो, कॉल द लीव मैटर।
Yesterday I appeared for food matters while activity was given by the marks.
Yes. Who is for the petitioner? Yes. What is the matter?
Lordship, the member of one ship Panchayatan Human Mandir their party assembly constituency. On 12th of April of Secretary of the Committee representation to the officer in charge of the concerned police station praying for permission to conduct Ramayan Chowal and Sundarkan Park.
When?
On 12th of April at the morning.
12th is over.
I'm coming. 12th of April at 1 PM. Sir, the respondent was 7. Came with his staff and his men and agents and threatened the committee members, including the petitioner, as there is a political party of this beside the committee, you cannot perform a religious practice. In this juncture, my lord, thereafter we have requested him that kindly do not do this because as per the Article 25 Constitution, we can practice a religious profession as we can do that. But he has paid no heed to that, and subsequently, this petitioner received several threat calls from several persons who have threatened him that you cannot do this practice at the local. And the third transfer, he has named your lordship. That can be ensured by the SCI to the training officer that we will perform the puja as per the requirements and no interference is made by the election commission of India. And we have also lodged a GD before the council decision stating that.
What is the prayer? What is the prayer?
To ensure this, sign comes to page number.
Practicing religious ceremonies,
yes,
ritual customs, and other practices of the Shiv Panchayatan Hanuman Mandir Puja Samiti. Yes. Whether you are performing this all puja in every year.
Yes, my lord. For last 10 to 12 years.
Where show where is the evidence every year you are performing the on this time? You might have been taken the resolution in every year. You might have been published the card. Where you show that you are. If you show every year you performing this, I will allow herein now. If it is the first time, this I will not allow because during the election period, this court. Sorry.
But day-to-day religious ceremonies, my lord.
One question, you are not understanding English. You show me the paper for the last 2 years, 5 years, 6 years. You are performing the same puja every year by this period, 12 to 20th April. Show me. The petitioner has filed the present application praying for. But you are not understanding when the court is putting the question. You have evidence, you produce me. Otherwise, I allow you to perform your puja after the 4th of May.
Come back tomorrow, my lord, with the documents.
Not today.
After the election.
Let the matter appear on 5th of May.
Grateful.
Let the matter appear on 5th of May. Yes.
Tomorrow, my lord.
Next. No, I did not file any emergency.
But the puja has been stalled for last 11
That's why you show where is the puja. There is nothing. There is no averment in your application. Where is the averment in the application? Every year you are performing the puja. Where is the averment, sir? Yes, next.
But may come back tomorrow, my lord.
7. Yes.
An active before the millet SI that your lordship will find my appeal at millet page number 24. That is annexure C. We have paid for this appeal on millet 15. Millet, my election is going to take place on 29. Whatever your lordship for the millet, your lordship will find at millet page number 25. Your lordship was.
Where is the rejection?
They have not passed a reason. My name is.
If there is no reason order, how the appeal preferred?
I tell your lordship.
If there is no rejection order, how you preferred an appeal?
List published on 27. I stand amended. That is the partition 25. In that Millard supplementary list, my name is not there. So Millard, consequently, Millard, I preferred an appeal. Your lordship will find that at Millard.
Whom you preferred an appeal?
You know the appellate authority, Millard.
At page number 24 that is appearing, the lordship will find that in the bottom portion the date has been mentioned, and my lord, the appeal number is also there in the top portion. Appeal number, APS.
Yes, state what is your submission?
Well, the election commission, my lord, is the,
The election commission has to.
they are the proper party. Now, your lordship passed an order in almost in a similar background, that is page 26.
Yes.
But I don't, I cannot stand in the way of passing this kind of an order in this matter.
Yes, election commission.
Your lordship, it has been served only yesterday.
So yesterday leave has been granted.
Need not to take any advice from the other.
Serve me.
Serve the copy. The only grievance of the petitioner in the present application that the name of the petitioner is deleted from the voter list, and according the petitioner has preferred an appeal before the appellate tribunal, being appeal number APS 2509 capital G 0204 26576 218 dated 23rd March.
On that day, division
And date on 2nd April 2026, but the said appeal is still pending, though the election is on 29th of April 2026. He submitted that if the appellate authority decide the appeal preferred by the petitioner, and if the petitioner name will be included in the voter list, the petitioner will get the chance to cast vote on 29th of April 2026. In view of the submission made by the counsel for the petitioner, the writ petition is disposed of by requesting the appellate tribunal to consider the appeal filed by the petitioner, being appeal number APS 2509G 020 42657 dated 2nd April 2026, and as early as possible, and to pass the reason order. Next. Yes, sir, from or fix time fix. Affidavit of service we kept with the record. ना 12 नहीं 12 बजे वाला क्या है?
Well, I was at number 170. And I'm the petitioner. No, this was my recap. So the hearing order was expiring on Monday. I said my lord specially to come back. It fixes it on Tuesday.
But the only thing that this is a matter in which the jurisdiction of RERA has been challenged. They merely went before the submitted to its jurisdiction. When they did not like another, they came up to the High Court challenging the jurisdiction. Thereafter, my lord, that was an ex parte ad interim order. Thereafter, we did not even have the chance to contest this, my lord.
Filed their opposition.
I filed my opposition, my lord, but it was not effectively heard thereafter. And to last date, they had prayed for an adjournment. Today, my lord, it is appearing, my lord. That is the only thing, my lord. And I can show I am armed with judgments of not of this honorable court, but a division bench judgment of the Honorable High Court of Punjab and Haryana, which says that the RERA has jurisdiction in cases even if the project is not registered under the RERA Act. There is a specific judgment because Section 3 and Section 31 are different to each other. Section 31 does not state that the project has to be registered with the RERA Act. This was registered with the earlier HERA Act that is gone, my lord. Now the RERA has come in, my lord. Now they say they suddenly take up the point that since HERA is gone and it was registered under the erstwhile Act, my lord, it's not registered under this Act, so this complaint is not maintainable before this forum. This is the point they have taken, and the proceedings has been stayed, my lord. In my humble submission, it can be heard out today, my lord, but whatever.
What you are doing,
my lord?
You are arguing the matter,
my lord.
Yes.
But since it's his
your argument is completed.
No, my lord. Since it's
without observing the court, you started the poem.
I'm sorry, my lord. I'm extremely sorry.
You seeing this since morning.
I bow down to your lordship. I bow down to your lordship in that.
This is not the so urgency that tomorrow heaven will fall.
I bow down to your lordship. In that case, my lord, let another date and time be fixed, my lord. That is my humble prayer.
That's it. Before the court has opened her mouth, you are starting all the things.
And I bow down to your lordship in regard.
No,
to
the
that.
advocate should be excited to do the matter, but see the position of
My lord, I bow down. I bow down to your lordship. That type. I bow down. That only thing is on the last date adjournment has been
though the
fixed.
matter is specially fixed today at 12 noon, but due to paucity of time, the matter could not be taken of hearing. Learned counsel for the respondent number 2. Respondent number 2. Right. Respondent number 2 raised objection and submitted due to the interim order passed by this court, the respondent number 2 is facing difficulties and he prays for fixing a short date for hearing of the writ application. At the learned counsel for the respective parties, let the matter appear.
One small request for your lordship, if the advocate on record, that she's getting married. She only made one request, if I could pass it. She's not available from 6th of May to 16th of May. Except for this period, we'll come back on any.
Then vacation start.
He's only made that she's not available. I understand. Her marriage will.
I also could not say anything. See that, your lordship, it has been extended. They have been entering appearance.
And
in fact, I don't.
I
leave it to your lordships. I'll bow down to whatever my lord decides.
It can be taken up before that, but whatever my lord deems fit.
Anything that your lordship will, at my lord's pleasure, will come.
Deems fit, but if
when 16.
After the 16th of May, anytime will come.
Starts from 6th.
6th of May, my lord. She's 5th of May, my lord. If they have some.
So where is the time?
6th. Anytime, my lord. Before, after, whenever, my lord. After we'll come back after vacation, whenever. I don't.
After vacation, my
lord. I'm enjoying an interim order.
Well, June. Well, June. 12 June 2026 at 12 noon. Interim order extended till the next date of hearing. Yes.
Could it be till the 13th?
Yes.
One extra day, for the interim. But your 6th and 12th, lordship keeps it till 13th.
12. Yes, next.
Most date.
1 PM to Monday रख देगा. दे दो.
118, I was praying your lordship can take up this matter on Monday. Or
Let the matter appear on Monday.
at 1 PM.
Same,
lordship.
1 PM.
Grateful.
Yes, next.
I am for the petitioner, my lord. That on 10th of April, my lord had directed the state to file a.
Yes, what is the matter?
My lord, I have a Tata Trevera vehicle which is registered as a private transport vehicle. Now state wants to acquire it for the election purpose. And I am that is what I have challenged, that it is I run a chemical factory. This particular vehicle is necessary. It operates only for the purpose of the company. It picks up my employees from a place and takes them to the factory. And my lord is aware of the judgment in Anirban Roy case, that private vehicle and private transport vehicle may not be covered by the provisions of 160 of the Representation of People's Act. So my lord, if my lord comes to page 23
yes,
of the petition, that is the my lord, registration documents.
Yes.
At the very top, my lord will see vehicle class, private service vehicle. Then my lord, the type of the type copy is at the next page, my lord. Maker's name, my name, everything is there.
Private sector vehicle.
Private transport vehicle. It never runs for any public transport purpose. Not given out on hire. And my lord, page 25 is the requisition.
Who is the owner?
My lord, the petitioner number 1 is the owner. That the company is the owner. My lord, that is the name is there. At page 24, my lord comes at the bottom of GTZ India Private Limited. I own this vehicle. I use it to ferry my employees
from various parts from a particular
Yes.
area from in the city
Yes.
to the factory. And my lord, the page 25 is the requisition. There is no date given as to when. We were sent a WhatsApp asking us to produce it on 25th. Thereafter, my lord, we have also received a phone call that produce it on 22nd. But may I rely on the judgment of this is reported in 2006, volume 4, CHN, page 207.
Yes.
But may I straight away take my lord to paragraph 14 onwards.
Paragraph
14 onwards.
Yes.
Under rather 15. The having thus ascertained the law on the subject, I shall now deal with the issues formulated above. Does the Representation of People Act, People's Act, authorize indiscriminate requisition of vehicle? It has been already noticed that the object is to hire vehicle for election purposes. The Motor Vehicles Act, in Motor Vehicles Act, there is a provision for a private vehicle defined under section 2, subsection 33 of the Motor Vehicles Act. There is a provision of public service vehicle defined under section 2, subsection 35 of the aforesaid Act, and there is a provision for transport vehicle under defined under section 2, subsection 47. Then the three sections are subsections are set out.
So your case is that private vehicle.
It's a private transport vehicle.
Okay. Then
my lord, paragraph 17 onwards or 18 rather. Section 66 of the aforesaid Act, or that is Motor Vehicles Act, imposes a complete ban upon use of a vehicle as a transport vehicle in public place except in accordance with the conditions of a permit granted for that purpose. This section, insofar as the same is material, reads as follows. No owner of a motor vehicle shall use or permit the use of a vehicle as a transport vehicle in any public place, whether or not such vehicle is carrying any passenger or goods, save in accordance with the conditions of the permit. But pausing here for a moment, my permit is to be used as a private transport vehicle. It's not a public transport vehicle. Then my lord comes to section paragraph 21. Then in 20, my lord, section 74 is dealt with, and in 21 it does appear that a motor car or an omnibus, and that I fall under the omnibus, meant for personal use of a owner cannot be legally be used for hire or reward. The ban under section 66 is complete, and any violation thereof will expose the owner to punishment under section 192. Section 160 of the Representation of People's Act, People Act 1951, therefore, in order to give a harmonious construction, has to be held to have authorized requisition of only a public service vehicle and at any rate a transport vehicle, for otherwise it would mean requisition for an illegal use. A motor car, leaves one line, a motor car, I have already held that neither a motor car or an omnibus meant for personal use is covered within the definition of a public or private service vehicle or a transport vehicle. There is still another way of looking at it. Anyone contemplating to hire a car would naturally look for a contract carriage or a cab owned by the transport operator. No one in his senses would think of gaining access to a motor car or an omnibus meant for personal use, or the owner, nor would he insist upon using the same for no better reason other than he is prepared to pay for hiring charges. This is precisely what the respondents have or have been seeking to do. Such an act is irrational and arbitrary and patently opposed to Article 14.
Yes, what is the submission?
Your Lordship, I'm appearing for Election Commission of India. The requisition was made by state.
Who is for the state?
Nobody is there today. There's a resolution. Notice was given to me sometime
Send them notice.
an hour.
Election Commission of India.
Your Lordship,
given-
requisition the vehicle. It was requisitioned by, we have checked our site. There are two portals wherein if we requisition, it will show poll duty. And when state does it for poll purpose, it will show. As DM issues all the documents that will be produced by state only. We won't have that access to those
But this is
documents.
also not the DM.
No, DM, this is request for requisition, which
Why
is
can't
issued
requisitions?
a month back. If you will, if your Lordship sees at the top, it is
Yes,
written
no
request.
document has come. This is the only document.
Your Lordship, in this regard, if your Lordship had passed a judgment with regard to South Point, it was taken up yesterday. Her Lordship had allowed out of 8 vehicles, 2 vehicles to be used. And because it's going to be an online procedure. And I had also last time handed over Madhya Pradesh High Court's division bench judgment, which distinguishes that transport vehicle means 6-seater and above bus. It does not mean it is private or public, and it can be used for poll purpose. The procedure has to be followed as mandated under 98, that requisition has to be received before handing over, and the date on which they will take the vehicle, that's important. Before that, it has to be served, just like CPC how summons are served.
Just to see what is the
The
procedure.
state has to be there.
State is, where is the affidavit?
Marat, I had.
Where is the affidavit of service?
Last time the advocates were appearing.
I have.
Mentioning now, where is the affidavit of service of the writ petition?
It's there, Marat, on record. And state.
It's the third time I think it's been taken up. It was mentioned and it is been taken out of turn. Your Lordship.
Today, have you issued the notice to the state? When?
Around 11:40 a.m. Marat, after mention. The other friend was also given.
Here the state. Where is the state?
Well, next page, well, the email will be there in the.
Email? Who will see in the court hours?
If they could inform the GP office, somebody would be there.
Why you not served the advocate? On the last occasion,
We served the advocate only.
Where?
By mail.
The second page, my lord, is Pannalal Bandyopadhyay is the.
Let it appear tomorrow at first
Where is
10
that?
matters.
Not served.
Yes, my lord.
See, this received is only CS received.
This, my learned friend was served by hand, and they were served by the.
Oh, where is that Panal? Where is the service?
Well, this letter was attached with.
Where is the service?
By email.
I cannot.
The petition, in spite of specific direction upon the petitioner has not served the notice to the state or respondent, intimating that the matter will be taken up for hearing at 2 p.m. When the matter is taken up for hearing, none appears on behalf of the state. This court finds the state is unnecessary, and before passing any order, the state has to be heard. Accordingly, case is adjourned. Let the matter appear tomorrow under the same heading.
May it appear at.
Next.
Much obliged.
You persons are.
He has a. He even made a phone call. He says that he has.
Next. So you could have been given to the PP office, GP office. GP office is here only. Why you not went? Next. I don't know. It will come tomorrow. We don't know when it will be heard. You persons are losing your chance. Then what the court will do? Every matter cannot be put in the top. Then, yes, next. Sir, 2 o'clock already matter is there, mine. Already today also fixed matter is there. Because of all of you, I could not take the piece of. You're not hear the dictation?
Yes.
Then? Who is appearing for the 9? None appears on behalf of the petitioner. Though the matter is listed as urgent motion number 1 and urgent number 3 on the mentioning list, it is fine when the matter is listed, none appears on behalf of the petitioner. Let the matter appear in the combined monthly list of July 2026. Next. Yes. Who has filed the report? Who is for the respondent? Yes. Hmm. Yes. Yes. But who is for the respondent? Yes, it is there. This one page out. This one. They filed any further report? Report is not here. Who is appearing? Issue notice, the state is not there. They have to be. Because they have, but Union of India. Union of India. Who? Yeah, I mean. Fifth of Yep. Who is for the Union of India? Yes, he is not here. कल क्या है? कल 2 बजे है? Okay. Learned counsel for the petition has filed affidavit in reply to the report filed by the respondent number 5. Let the same be kept with the record. As none appears on behalf of the Union of India, thus the case is adjourned. Let the matter appear tomorrow within 5 matters under the adjournment 1. The petition is directed to inform the learned advocate appearing for the Union of India regarding the date. Yes. Oh, won't copy दे दो, report का copy है ना? Yes, tomorrow. Yes, next. इससे पहले भी जो था ना, गाड़ी वाला, उसको भी वही 4-5 बार. Yes, next.
Item 11 konta 12 point. I appear for item 11 and 12 both.
Yes.
I'm for the state in 11 one.
11 and namta bolo to. 11 and namta.
Lakshmi Hemram. Lakshmi Hemram to do.
Like this case, Millard, of an unfortunate couple who couldn't conceive through Millard the natural process. Seeking my lord's leave, Lord, to go undergo the process of surrogacy. We have obtained the certificate from the medical board. Now, Millard, since Millard the age of the husband is above the threshold criteria under the act, So, my lord, we have to take permission, my lord. Similar kinds of orders, these kind of, my lord, matters have been considered earlier, my lord, by Justice Amrita Sinha. One of the flagship judgment, my lord, is Shamuli Shaha. I'm আপনাদের আপনার কাছে নেই শ্যামলী শাহ?
No. How could I know that you will rely on
শ্যামলী শাহ, my lord, is the
every matter?
For that,
very well in that case.
before that, the Sanchita is there, wherein the section has been interpreted.
My lord, by our court, because there are
Yes,
judgments of others.
Justice Sabyasachi Bhattacharya.
Oh, but I was not aware of this.
Why you are not aware? You read this. Kindly see the. Why you are not aware? Kindly come to the
That
paragraph
Sanchita-
19.
Yes, yes, my lord. I mean to say that judgment I don't have.
Paragraph 19.
Yes. Then, my lord, in that case, my lord, may I cite this order, my lord, of Justice Amrita Sinha, my lord, which I have extra copy.
Paragraph 8.
Yes, my lord.
Sudarshan Mandal and Sanchita girls.
Yes, my lord.
Yes.
No, I will not stand in the way for lordship.
Yes. Where is your
medical board permission?
Yes.
But that
When you married?
We got married, but that date is not missing, my lord. But my lord, we have the certificate date. That's 25th of August, 2025.
2025 you married?
No, the medical
When you
certificate.
married?
Married, my lord. It's not mentioned. Kindly gives me a moment, my lord. It's not mentioned here. I have the age.
Not mentioned.
Not mentioned.
Then you have to first establish you are having the so much year of the marriage, you could not conceive, then went to hospital, continuous medical treatment.
That I have pleaded, your lordship.
Pleaded. Where is the document? Since when you started medical treatment?
Medical treatment documents, my lord, I have annexed.
2025.
Yes, that's at page 2025.
Then
page
when you started, when you married and when you continue under medical treatment, there was an observation by the doctor that you cannot conceive.
Yes, that observation is there.
That is 2025.
2025.
Then that's why what is the distance between the marriage and the certificate? And this is the first date the doctor has given the certificate.
No. So there are two, my lord, as far as I know, my lord.
Sir, as per the procedure, I am telling you.
Yes, my lord.
First, you have to establish the date of marriage. From the marriage, what are the years? So you had been to the medical treatment. In spite of the medical treatment, you are not able to conceive that. That's why now you have taken the advice for
surrogacy.
But so far as marriage is concerned, my lord, may your lordship keep the matter
you
tomorrow.
persons are not making any case and coming with the
I will come with the marriage certificate, my lord. I shall demonstrate.
marriage certificate will not
and
serve.
also
I am telling not
yes.
serve the purpose. After the marriage, whether you have gone under the medical process.
Those
documents are not here. But this is a
So you supplementary if you are having
supplementary.
As you lordship.
Then your lordship kindly keeps it in next week.
Blanket order cannot be passed.
Very well, Lord. I shall.
The petitioner prays for time to file supplementary affidavit disclosing certain documents. Accordingly, prayer is allowed. That supplementary affidavit filed within a week from date after serving the copy to the land council for the respondent. List the matter on 7th May under the same heading. Bring all this.
Yes.
Next.
12 also, Lord. Same. But this is IVF, that was surrogacy.
Bring all that thing.
Very
great. 11 se. Next. No file. File is not there. What is the matter?
Sir, about my lord, relating to my lord, the payments which was made regarding the area salary was made in the year 2004. Also, he care on 2003.
Huh?
2003.
2003, he retired. When you got the pension benefit?
My lord, pension benefit was thereafter, my lord, subsequently after the death of the my lord.
When you retired? 2013.
No, 2006.
2006 you retired. When you got the pension benefit?
My lord, subsequently, my lord, 2009.
2009 you got the pension benefit. And you died on?
Died on my lord 2020.
The government servant died on?
2006, my lord. He died on my lord.
Okay, not today. File is not there. Next.
14.
File not there.
Next. This is
Able to file my lord affidavit.
Come tomorrow.
This is my writ petition, declaration of fraud. Now, here, my lord, there was earlier I was declared as fraud. Along with me, another director was my husband. He was also declared as fraud. Now, my lord, in respect of my husband's writ petition, Harish Bagla's writ petition, my lord had already passed an order directing, my lord, the forensic audit report to be made over, and thereafter, on the basis of the forensic audit report, a right was given to him to give a show cause, to give a reply, or to give a further supplementary reply to a show cause notice. Now, in my writ petition was pending, there was no such direction in my writ petition. Now, I have received a further declaration of fraud. No forensic audit report served on me. I'm the other person, I'm the wife. No forensic audit report, but further declaration of fraud on the ground that since I've given the forensic audit report to Harish Bagla, that is my husband, and he has responded. So therefore, I'm declaring you, and along with this fraud also. My point here is very short point. I had separately challenged the fraud declaration, which is still pending. Now, today the bank has also treated this, since my lord has set aside the earlier declaration in respect of Harish Bagla. The bank had already treated, let's say, that I'm also covered by that. That's what the bank has treated. That being the position, I was supposed to serve with a forensic audit report because I'm also an independent. I'm a separate legal person. So I have an independent right. So if the bank gives me a forensic, that doesn't give effect to this declaration and gives me, then I'll also get a chance to give a reply to this. Now, only thing my lord will kindly see is
that I am appearing on behalf of the bank. May I cut short, my lord? Admittedly, my lord, I cannot, my lord, take a different stand what I have taken, my lord, in writ petition 28686, my lord, to be given, my lord, lawfully, my lord. Only thing, my lord, 3 more writ petitions are pending on identical issues. My lord, my humble prayer, my lord, if my lord kindly fixes all the.
But what you have in total details of the writ petitions? How many writ petitions?
Three, my lord, in which, my lord, I am appearing. Kindly fix a date, my lord, together, my lord, Lord's Smith.
Only in the meantime, my lord, let them not give effect at least
tomorrow, my lord, tomorrow or Monday.
Same petitioners?
Same petitioner. Identical issue is in for FIR.
Where is the order? Where is the order?
Yes, my lord, the impugned order is at page 97.
97 is my order.
Sorry, page 91, and my lord's order is at page 97, and page 91, where my lord will find the findings at 95.
Computer and object due consideration of facts and evidence on record held by Mrs. Samrita Foods and his director as fraud on the ground of misappropriation of fund.
95 and 96. Bottom and 96.
No, in this case, the writ petition, my order was considered.
My lord, yes. Now what has happened here was that my lord's order was in respect of Harish Bagla's writ petition. Whose husband was challenged separately, my writ petition was there separately. Now, I have been once again declared as fraud on the ground that pursuant to my lord's order in Harish Bagla's writ petition.
Where is earlier declaration?
Earlier declaration
set aside.
That my lord has already, my lord has
this lady.
This lady,
yes.
No, that is still pending.
That's why that original is not set aside.
That is not said that
my order is passed. In terms of my order.
Yes.
In the case of her husband.
In case of her husband. Without giving me the copy of the forensic audit report.
Very forward. Bank is very forward. Yes. What can be done?
But FIR to be given, my lord, admit.
Huh?
FIR to be given, my lord. Admittedly, my lord.
If I it to be given, but problem is that the original fraud order, original declaration of fraud order is still pending before this court in a writ petition.
Yes, ma'am.
That this court has not heard, neither set aside. And pending writ application and in existence of that fraud order and declaring fraud, not fraud order, declaring fraud, then you have again passed this order. So which order will prevail?
Kindly fix all those matters together.
This possibly is a unique case compared to the other fraud matters.
So this order and that order has to go. Then you have to pass a further order after service of the FIR.
Yes.
ठीक है?
Yes. And the earlier is at page, my lord will
96.
find, yes.
Where is that earlier order?
Yes.
But
Page
that rate
55.
petition is not here.
That is listed, item number?
When it will be listed, any date is there.
Yes. WPA 1663 of 2026, page 11, paragraph 38, the number is given.
Page 11.
Yes, page 11, paragraph 38.
But that petition is to be brought on record.
No, it's not there in the list, but then this number is given.
You are given this, but where is the number of the
The number is there.
Huh? देखो number अच्छे की.
WPA
number नहीं.
1633.
Okay.
I will not give number.
WPA 1633 of 2026 is my, was whereby I have challenged page 65.
1633 of 2026.
That is
19366 of 2025 and 831 of 2026.
1933 relates to willful defaulter, not fraud declaration per se.
But not challenging contention is the same. Not FIR has not been given.
एक काम करो ये वो तीनों मैटर और इसको कब रखेगा आज कितना तारीख है इलेक्शन के बाद रखो इलेक्शन से पहले कुछ नहीं होगा 8 तारीख
Only in the meantime let them not give effect to this declaration.
Not to take any further.
I will
inform the bank.
Yes.
Record an order and then let counsel for the respondent submit that the analog and there are analogous 3 matters are pending before this court and press for fixing all the matters together so that all the writ petition can be disposed of. In view of the above, let this petition along with the other pending writ application connected with this case be placed on 8th of May 2026 within 5 matters under the adjourned motion 1.
Let me kindly add that no further coercive measures in the meantime.
I will instruct.
Yes.
I will inform.
Then you come.
Because I'm to say any embarrassment, but
advocate is there.
Well, affidavit of service may be taken on record.
Affidavit of service kept with तारीख. Next. 15. Give. Resolution है ना बस खत्म कर original site
My lord, not mentioning for recording my name in order sheet, my lord.
petition देना है
Not mentioning, my lord.
हाँ
Not mentioning for recording my name in order sheet. My lord,
which matter
my lord, yesterday I appeared in 4 matters. In 2 matters I given slip. But by
yesterday I have heard 26 matter which matter you are
Mandarmani hotel demolition.
Huh?
Mandarmani hotel demolition.
I can't
119, 120, my lord.
so order pass uploaded
Not uploaded, but just
uploaded or not
correct.
उसका नाम ले लो जरा मार्क हाँ
2 matters.
मेरे पास साइन गिलिन और लेख की उसमें भेज दो मेरे को अर्दली के साथ भेज दो petition number डाल या
My lord, I pray for small indulgence, my lord. Item number 16. You completed up to 15. I'm waiting for 16. Now 16, the matter is the writ petitioners are not there. I'm for the respondent number 6. First thing is that the respondent number 6 has already retired from service and he is no more the chairman of the one of the committee, who was a respondent. There is a new chairman. And secondly, my lord, this is my personal this one. I will not be in Calcutta for the next week. So if the matter is, this is item number 16. Nobody is appearing for the writ petitioner. I'm responding.
writ petitioner nobody is there you are appearing for
No,
I'm for 24.
Nikita Tulsian.
item number
16.
16 file is not there it will not be taken don't worry
But item number
Not permanent.
if it listed you could inform this court your junior will inform this court I will accommodate that
item number 24, item number 24, the respondent is here.
The respondent number 1, Milan.
Hearing. The Lordship keeps it on because tomorrow they also again have problem. They said, they told us informally. So
which one?
Item number 24. I've spoken to them. They said tomorrow also they will be having a problem.
My senior is
Finally on Monday or Tuesday, according to Lordship preference.
Let it be in the list. If it come, you take adjournment. I will
Lordship keeps it at 2 o'clock or any
2 o'clock, June.
Oh, no, no, no.
Maintain it.
Or it may maintain its position in the list. That's good.
Ah.
Maintain position.
24.
Serial number 20. लिख के दो.
The court was sleeping whole day. That's court was sleeping whole day. Then you are telling that you were waiting for a whole day. Court is what the court was doing here. What is the matter about?
Lordship, it's a premature release matter, Lordship.
Premature release. I have fixed one date. All premature release matter.
Lordship, today suddenly it has reflected all.
No, that's a year matter is already there. But other matters are there. I will see today, and all the matters will be.
Item number আমাদের 20 আমাদের 18 19 20 আজকে ফিক্স হয়েছে premature release
18, 19,
20
These are all.
all
That's
Lordship.
why this is fixed today. But what can be done? Let it be remain in the list. Come tomorrow. Tomorrow the time will permit. I will take all the matters.
Lordship, since I've got a little chance, they are in custody for 40 years.
That's
almost.
why I have gone through your mentioning list. I have kept all the analogous matters so that I can hear and dispose of the matters. Correct.
Great.
Come tomorrow. I will not delete this matter.
Thank you.
Yes, I will take
Sir,
that.
tomorrow.
Next.
Grateful, Lordship.
इसका क्या करेगा बाद में जज में ऑर्डर देगा क्योंकि मेरा चैम्बर में भी एक ऑर्डर ना चैम्बर में दूसरे जजमेंट चलता है तुम आ जाओ डिक्टेशन देगा आ जाओ चैम्बर में या तो फिर यहाँ में आ जाओ 4:30 बजे हम यहीं डिक्टेशन दे देगा यस नेक्स्ट Yes, call.
Yes. May it please, my lord.
Yes.
Well, on the last occasion, I placed the trial court judgment in the earlier suit.
Yes.
Today, my lord, I will just take a little bit of time to place the division bench. Then after that, it will just be the arguments. Volume 1 of the documents, if my lord takes, page 36. Page 36. APD 350. I'll go straight into it because that will also recapitulate the facts.
Yes.
So I got a decree in my favor in the 87 suit. Now the bank preferred this appeal. Then quickly, I'll just take my lord through the facts. The important thing, if I may say so, my lord, to remember is that my decree was upheld. But the bank made, the division bench made certain observations which apparently gave the right to the bank to file a suit if they were so aggrieved. Now I am saying that what the leave that has been given in this judgment, I'll show, is not what they have come before my lord in the new suit. That's number one. And also this will show that all the issues they've raised now has been already decided in this matter. Now, if my lord comes to page 37.
Yes.
I don't find my learned friends there, but there's no adverse order. I said there'll be no order today. So then we can continue. RK Agencies Limited made a fixed deposit with the central bank through their advocate Khanna on May 27, 1984. Well, this letter I have placed, but just to remind my lord, this is what caused the confusion. Your lord, you will just see the letter once. Under instructions and on behalf of my client, RK Agencies Limited, we beg to enclose check for so-and-so, rupees 20 lakhs drawn on Allahabad Bank in our favor with a request to have the check encashed and put the proceeds in a short-term fixed deposit for 6 months, carrying your usual interest. The original fixed deposit receipt may be kept under lien by the esteemed bank, and if necessary, we will formally discharge, well, it should be for A actually, formally discharge the same in favor of the bank. We agree that the said receipt will continue to remain under a lien with the bank and may be renewed from time to time for identical periods pending RBI permission as stated hereinafter. Needless to add that appropriate permission will be applied for and obtained from RBI in consultation with under advice to you for credit of the said sum to foreigners' account as and when such permission is granted. The short cases, we did not apply for permission. We didn't want to send the money and we asked for the money back after 6 months. But then the bank refused. We filed the suit. In the suit, in the chapter 13A, for the first time, bank discloses they had applied for permission and they had been declined permission. So what the division bench ultimately holds, as did the earlier judge, that without this permission, it's a non-starter. If there's no permission, it cannot be sent to a foreign. It's a contingent contract, and therefore you return the money. Now, the contents quoted above.
Why it has been said as kept under lien?
Yes, that was a lien letter was also given. So a fixed deposit can be kept as a lien, but only if a debt, I owe the debt to the bank, that would be kept as a lien. But in this case, there was admittedly, I have cross-examined the witness. He says we have no debt to the thing. So it was a contingent thing. It didn't happen. But they are taking advantage of it and trying to suppress the fact that they earned money from this fixed deposit for the last so many years. Contents quoted above would show it was not a fixed deposit simpliciter. It was kept as a collateral security that would continue to remain under lien with the bank and would be kept renewed from time to time. This is the important word, pending RBI permission. The permission was required for credit of the said sum to a foreigner's account. The account was, however, not specified. Even till date, they've been flip-flopping from SL Setia Liners, Drum Place Limited, Ranjit Setia, etc., etc. None of them have been made parties in this suit either. Then, it appears Central Bank of India applied for permission that the Reserve Bank declined. Messrs. Khanna prayed for encashment of the letter dated 28th May 1985. Khanna and Company in the letter observed, this is also important, the understanding for arrangement sought to be arrived at in terms of our letter of 27 November 84 was never acted upon and nothing definite was achieved between the parties. So we clearly said that we wanted to do this thing, we didn't do it. Then RK agencies filed the suit claiming a decree for 28 lakhs odd being the proceeds of the fixed deposit. The bank contested the suit by taking the plea of adjustment. According to the bank, RK agencies would belong to one Setia group that did various overseas transactions, spelling wrong, overseas transactions with the bank. The bank had already filed a suit before the Queen's Bench Division in the UK against SL Setia Liners and KC Setia Limited on a money claim. The bank would contend that the subject fixed deposit was nothing but a deposit to the credit of the said claim. Hence, RK Agencies Limited would not be entitled to any decree as prayed for. The learned judge rejected such contention and decreed the suit. His lordship held the fixed deposit was subject to credit of a foreigner's account that the Reserve Bank did not permit to transmit. Hence, RK agencies would be entitled to the proceeds. Moreover, the bank failed to establish a nexus between RK agencies and the overseas litigation. Being aggrieved, the bank preferred the instant appeal and we heard on the above dates. Now, the same conclusion will be drawn by the division bench, but here the division bench says, no, that there is a nexus between the Setia, Mr. Ranjit Setia and RK agency. And then they leave the bank to it, to their thing. They take appropriate action in accordance with law. So I'm just sure. Now, the submissions that were made before, it just so happens that I was there in that earlier litigation as well. All these facts that have been submitted in the division bench were not, now in this suit, it is revealed. One thing was submitted, the accounts were transferred to India. Therefore, no permission was required because now the account is in an Indian account. Now it turns out no account was transferred. In fact, the bank closed down in London. Everything was written off, and there's a profit and loss account of that branch. But the account of Setia Liners was never transferred, and it was on that basis that there was a lot of discussion. That is number one. And second is the impression, as will be seen from here, is that they had a decree against this SL Setia liners, which now they've admitted. He said, I can't say. There's no decree on record, and according to us, there's no decree at all. So it was totally misled. They showed a decree against another company, Drum Place, but they don't claim to have just this amount against that claim. So that is, these two things will come out very clearly. That's why I'm placing this decision. And what should be the scope of
what they have made a counterclaim? What counterclaim they have?
No, this is their suit. This second.
What they
So
have?
now they are saying their claim is only one prayer. Declaration that the account, that the money was kept as a lien, it is a valid lien, and it is in favor of Drum Place and or SL. So it's a declaratory relief has to be either one or the other. But it's vague in many ways. One straight after this order, I will place the Supreme Court decision, which is 1 page, and thereafter I'll take my lord to the press. SLP. Mr. Such and Such senior counsel placed the pleadings as well as relevant correspondence, page 39. Mr. Mitra would suggest that the letter dated November 27, 1984 was not a deposit simpliciter. It was on a lien account that would be supported by the letter of the overseas advocate Zaiwala, dated February 11, 1985. He would also rely on a subsequent letter of Zaiwala, July 4, 1985, that would relate to the deposit of RK agencies. Mr. Mitra placed all the correspondence, including a letter of Simmons and Simmons, the overseas advocate acting on behalf of the Setias. Well, it should be Simmons and Simmons was the bank's lawyer, and Zaiwala and company was SL Setia Liners advocate. So there's maybe a typo here. Dated May 30, 1986. He would refer to the Reserve Bank correspondence of 5th September 1986 and July 2006 in this regard. Well, I've shown these letters to your lordship. In my list of dates, I'll show 5th September 86 was an order of Reserve Bank blocking this RK agency's account. And 26th July, I think, was when they deblocked it. They said there's no violation of FERA, nothing. They deblocked it. So these two letters are to do with something else. Then he would also rely on other correspondence exchange between the bank, Setias, and their lawyers, and would contend that the deposit receipt was duly discharged by RK agencies. Once it got discharged, the bank became the absolute owner. In any event, the plaintiff did not examine any representative of Khanna and company connected with the deposit, so he could throw any light on the same. Mr. Mitra would heavily rely on paragraph of Zaiwala's letter dated 4th July, and the paragraph is quoted below. Well, I am relying exactly on this paragraph to show that the bank in London had rejected the proposal given by Zaiwala that we will deposit money in India, 20 million rupees, and it will be sent to England. Now, then what happened was the advocate of the bank, to whose letter this 4th July 85 is being replied to, I will place Exhibit 4 separately again. I'm just telling my lord ahead. The advocate wrote that there is no such deal. We are going whole hog. There's no collateral of 20 million rupees. That is why this letter. Now, your lordship sees what the letter says. With regard to the deposit of rupees 2 million with your client's Calcutta branch, our clients, that is SL Setia Liners, are simply appalled that your clients, by acknowledging receipt of 20 million from our client's Indian solicitor, Khanna and company, would plead ignorance of the fact and that these monies were deposited on our client's behalf. If your client now wishes to ignore the deposits placed with them by Messrs. RK agencies on our client's behalf of Messrs. Khanna and company, our clients have asked you to take instruction from your client and confirm that the bank would allow RK agency to withdraw the deposit. So if the bank themselves are saying they didn't accept this arrangement, so this arrangement, basically, my bottom line is, without RBI position, whatever these persons had agreed or spoke about in England doesn't apply to this Indian company at all. Then in support of his contention, these two decisions were placed. He would refer lastly to the last paragraph of the judgment to suggest it was based without any support of law. Then, per contra, Mr. Mukherjee, senior counsel, he was appearing for RK agencies. Senior counsel would refer to the written statement filed by the bank and contend that the cases cited at the bar would have direct conflict with the pleadings that the bank used before the single judge. Because here they started saying that the account had been transferred. Then they said we have a decree against SL Setia Liners. These were all contrary. Then Mr. Mukherjee would specially refer to the exhibits being the correspondence exchanged by the bank on the one hand and the plaintiff on the other to show that there was no reason for withholding the deposit even after deblocking. He would contend under the agreement pleaded by the bank, the plaintiff was supposed to obtain permission from the Reserve Bank under the Foreign Exchange Regulation Act to repatriate the sum abroad. The plaintiff did not make any such application. The bank made the application and the Reserve Bank refused. Hence, the so-called lien for which the bank would write to the initials would write at the initial stage would be invalid, and the plaintiff would be entitled to get back the mature value of the fixed deposit. As far as and by way of alternate submission, Mr. Mukherjee would contend that if there was a contract to keep money deposit earmarked for payment to a foreign account in the absence of RBI permission of RBI, such contract would be void and not enforceable in law. He would heavily rely on Section 32 of the Contract Act to support his contention that a contract based on a contingency would become void in the instant case. So no permission, no contract, end of story. According to the bank, the fixed deposit was kept in lien, earmarked to be credited to a foreign account, subject to RBI permission. There was no certainty on RBI permission. Hence, such type of contract would be void under Section 32 of the Contract Act that the learned judge erred in appreciating. Mr. Mukherjee was critical about the letter of 7th August 2006. The bank appropriated the money without any reference to court, then that would be illegal and would be liable to be set aside. If I may pause here once more. They, in the middle of, while this suit was pending, then when the deblocking came, they said the blocking, there was no interest had accrued. It was completely standstill. And then the moment they got the letter on 26 July 2006 to deblock, on 7th August, they allegedly appropriated the sum. And then they applied for amendment of the written statement to say they have done this. So obviously the trial judge also was very livid at this, that the suit is pending, the hearing was going on, and then you've gone and taken the money. So they claim that they've taken the money. But what they suppressed was, they took about 1 crore 10 lakhs was transferred, but they showed us only 20 lakhs 60,000. That again has come out in this suit. Then, on the issue of deblocking, Mukherjee would rely on the letter of the 23rd and 26th July, wherein we find the Enforcement Directorate categorically observed no charge would be framed under FERA, and thus the fixed deposit was deblocked. Mr. Mukherjee would contend after such deblocking, the plaintiff would have no claim whatsoever. Deblocking letter. Okay. It's in the list of this. On the issue of interest, Mr. Mukherjee would contend that the bank unnecessarily harassed the plaintiff. Plaintiff was entitled to the proceeds of the FD on the date of maturity. Once it was kept pending, the bank was obliged to pay interest on the said sum as per prevalent bank rate, and that too with half-yearly rests as per terms and conditions of the fixed deposit, as if the fixed deposit was kept renewed every 6 months. Now, this is very important. We had made this submission. They countered this submission in the reply saying, no, there was deblocking, no interest accrued. And when we find out that interest had accrued and they had purported to transfer more than 1 crore instead of 20 lakhs to Bombay, when I cross-examined their witness in this suit, he says that is done at the savings bank rate of interest. So that also is, I of course do not want to undo my own decree in this suit, in their suit. But my counterclaim is based on all these new facts, new admissions that have come up in this suit, and I've claimed my compensation. Then these decisions were relied on. This is to do on contingency. Page 45, he lastly distinguished the cases. No, that's not important, Then, if my lord comes to paragraph 40, page 46, page 46. While giving reply, Mr. Mitra contended respondent did not deal with the issue of foreigner's account. What was the foreigner's account? Zaiwala clarified, as it will appear from page 18 of the compilation. The respondent did not deal with this aspect. Mr. Mitra contended lot was said on section 32 that would have no role to play as the transactions could not be said to be contingent contract. He would refer to Khanna's letter, which clearly indicate money was to be transferred to the foreigner's account. What was meant by lien was absolutely clear from the documents exhibited for the purpose. Foreigners' accounts of Sethias was here's the submission, was transferred from London to Bombay. So they tried to make that submission. And the bank was entitled to appropriate the sum. He would distinguish the case of such and such. In the said case, there was no contract that would be clearly distinguishable from the present situation. Well, these submissions of Mr. Mitra were rejected, but yes. I'll come to that. Adding to what he said earlier, Mr. Mukherjee contended there was no case made out under section 131 of the Transfer of Property Act. It was nothing but an afterthought. In any event, the same would have no application in the instant case. The parties never exchanged any correspondence giving mandate for appropriating the amount. To appropriate the amount. The contention that FERA permission was not required was never made. Before we deal with the rival contentions, we first examine in detail the documents exhibited by the parties, as the decision is in the present list would lie on the interpretation of rival documents. The letter of Khanna dated 27th November would indicate that a check of 20 lakhs drawn on Allahabad Bank was sent to the central bank to be invested in a fixed deposit that may be kept under lien, subject to appropriate permission of the Reserve Bank, and for credit of to the foreigner's account as and when such permission was granted. From the letter, it is not clear who was to apply for permission. The bank applied for permission and the Reserve Bank declined. Hence, the purpose for which the amount was kept in deposit was frustrated. This is the finding of the division bench. The bank heavily relied on the letter of Zaiwala, who acted for the Sethias. Their letter would denote a sum of 20 lakhs was to be deposited against the indebtedness, and the amount would be set off against the dues of the Sethias. Hence, the amount that Khanna deposited was to be appropriated against a foreigner's account, meaning thereby Sethia's dues were required to be adjusted against the proceeds of the fixed deposit. However, in the absence of the permission, the same was not possible. Again, it's held without permission, not possible. The respondent would contend it was a deposit simpliciter. We are unable to accept that. The documents were sufficient. This is the finding that changes the division, the trial court order slightly. The documents were sufficient to establish the nexus. The dues of Sethias were to be adjusted against the deposit. To that extent, the bank was able to establish the nexus. In this regard, we may take assistance of the letters of Simmons, another advocate, that would discuss about the proposed settlement between the Sethias and the bank. Mr. Mitra contended, since London account, again it's written, London account was transferred to Bombay, never was. Permission was not required and the bank was entitled to have adjustment. Even if we accept such argument, we are unable to appreciate how without a court proceeding, money could be adjusted, particularly when there was no clear mandate on the score in the letter of Khanna making the fixed deposit. So there has to be some adjudication that the SL Sethia liners, there should be a decree against it. There should be a decree that RK agency has promised to give this money and we are adjusting the money of a third party. No adjudication by anybody. Suo moto, the bank purported to appropriate it, which was held to be illegal here. If we bring the controversy to a narrow should be compass, it should be compass. Then as we get on a composite reading of the documents, we would find Khanna deposited 20 lakhs earmarked for payment to a foreigner's account. What was meant by foreigner's account was not clearly spelled. Under the appropriate laws prevalent at the time for transfer of money from the country to abroad, permission was required, such permission was denied. Even if nexus was proved, it would indicate transfer of the proceeds of the deposit to a foreigner's account. In the absence of permission, money could not be transferred. Mr. Mitra would contend the account was transferred from London to Bombay. No sufficient evidence came out. Even then, and now it's come out that it was not transferred. They've shown a letter that it was written off before the bank closed December 3rd, 86. Now, this is what happened in the division bench that changed things a bit. Just on the eve of closure of the hearing, the bank filed an application for additional evidence. We were not at all satisfied on the grounds of non-disclosure of those documents earlier. By the judgment and order dated 25th July 2014, we dismissed the said application. We held the second document was already on record and the other two were not binding. So that was, now he discusses those documents. This was the new case that they tried to bring just at the fag end of the argument. Even if we take into account these three documents, we would not be in a position to conclusively hold in favor of the bank. The first is a letter of the bank dated 21st February 86, was with the application of the bank made to RBI. There, the bank gave details of transactions. According to the bank, the deposit was held in the name of RK Agencies Limited. The controlling block of shares was held by Setia and would relate to Ranjit Setia, who was a debtor in the London account. Next document was 9th January 85, was a decree passed by the Queen's Bench Division against Drum Place Limited, amounting to such and such dollars. And the third document was a letter of Simmons written to the bank solicitor at Calcutta, giving appropriate advice for enforcement of the decree. The third document, being an internal document, between the London solicitor exchange with its counterpart at Calcutta, would be of no consequence. But except the fact that they, in their own showing, said that there was a decree against Drum Place, their lawyer had been told, enforce it. Till date, there's no execution application as far as Drum Place. And they show the court, no, we have a decree. Now
what has happened to the decree?
Nothing. We found out it's been executed in London. That Drum Place company was wound up. It's there. They have inadvertently disclosed everything now. And that's why we have disclosed even the suit they filed against SL Setia Liners. The bank couldn't say whether there's a decree or not. But on pleading, not just here, but before, I'll show the next document. There are 3 more pages. Well, I'll let me finish. Don't want to jump ahead. In the Supreme Court also, they make these same contentions, which now they are going back on. To enforce the decree against Drum Place Limited, an appropriate method should be adopted by the bank. Now, this line is very important for us. The bank suo moto would not be entitled to appropriate even if we give full credence to the decree of the Queen's Bench Division. So even if they have a decree there, they can't take my money here. They'll have to execute it. There's a way of doing it. As observed here before, the decision in this case would squarely lie on the interpretation of the documents, etc. The decision in such and such would relate to section 32 that would have relevance in the present case. And the distinction made by Mr. Mitra would perhaps not be a correct one. We fully agree with Mr. Mukherjee that no inconsistency there is no inconsistency in the pleading, and the observation of Lord Denning in such and such would have no application. Dealing with the cases, the decision in Mubarak Ali was relied upon the proof of the genuineness of documents. Since we give full credence to all the documents that the parties exhibited, the issue may not be dealt. That's done. Then, to sum up, we find Setia's had dues in London. Another typo. The Setia owed, but anyway, the bank, maybe the bank had due. Then Setia had dues in London. If the meaning is clear though, if Drum Place Limited is a company of Setia, it did suffer a decree before the Queen's Bench. Central Bank was thus entitled to enforce such decree, provided it lawfully enforced through appropriate mechanism. Suo moto appropriation on the pretext of a transfer of account from London to Bombay would have no factual or legal support. Then, the money was certainly deposited to square up because of the Zaiwala's letter, which is a third party's letter, but it obviously has had an impression on both the trial court and the division bench, because they mention 20 million rupees will be deposited in Calcutta, subject to permission. That was there. So then the money was certainly deposited to square up the foreigner's account of Setia. That would depend upon the permission of RBI. RBI declined. Hence, Section 32 would have a role to play. The bank suffered deblocking for considerable period. Once the Reserve Bank deblocked the account and the Enforcement Directorate exercised their inability to frame any charge to block the account, the money was liable to be refunded. The holder of the fixed deposit would not be entitled to contractual interest for the whole period in the facts and circumstances as discussed above, to the extent the cross objection fails. So I never got the interest because they said it's deblocked, and that's again repeated before the end. We agree to the ultimate finding of the judge, however, on independent appreciation of the facts. The same time, we intend to give an opportunity to the bank to have appropriation of the amount through proper court mandate being obtained for the purpose. This is the clincher. Now, what is the division bench cannot be saying here? We have adjudicated your appropriation is wrong and the ARC agencies to get the money back, and yet we are giving you another chance to do that. What the division bench is saying, we are giving an opportunity to the bank to have the appropriation of the amount through proper court mandate. So they have to get a proper court mandate and take this amount. Now,
So the appellate court is of the view they have to execute the decree of
drum place. That was in the mind of the.
Because what if we read together, the court is in the mind that they are claiming this amount with regard to the execution of the decree, but they are not come to the decree and they wanted to take the amount without following the due process.
Execution. That was because they waived that decree. Now they've disclosed the decree, but they are also saying that we had a decree against SL Setia. They didn't have a decree. So, but even then, the division bench is certainly not saying you can re-agitate every ground there is on lien, on who is the foreign party, on RBI permission. All that has been decided. So what they could have said is, I have a claim against you, and you were a guarantor for this party, and now once the bank gets a decree, they could have attached my decree. What they've done, they've stayed the execution of my decree. Then the appeal succeeds in part. The decree passed by the learned judge would remain stayed for 6 months to enable the bank to initiate appropriate proceedings, to have appropriate mandate for adjustment of the fixed deposit proceeds against their claim for adjustment. In case the bank would fail doing so, the decree would be executable upon expiry of 6 months. Now, Supreme Court doesn't interfere with this except extend it 1 more month. Then they file this suit. Then we make it clear. This is also important. We do not express any opinion on the enforceability of the Queen's Bench judgment for the purpose of appropriation of the subject fixed deposit. We do not vouch for the authenticity of the said decree. It would be for the appropriate forum to judge the authenticity of the decree, enforceability thereof, and the bank's competence to appropriate the proceeds of the subject deposit as against such decree. Our decision can only be used as an establishment of nexus to the extent we pointed out, no far, no less. Then we have fixed 6 months to enable the bank to approach the appropriate forum. In case the appropriate forum is approached, it would be for the forum to extend the period so that they can finally resolve the matter. Then what they did, they filed the suit, they put in the money of 28 lakhs decree with interest. They've put it in and that's into the fixed deposit. But after this, now your lordship will see the prayers in the suit, the plaint. My lord takes the plaint, page 14 of the plaint. Now, having read this division bench judgment, is this the suit that the division bench envisaged? If I may put the question.
Now the question is that the decree of the drum press can be executed through a fresh suit.
Yes, but any other decree that you have, or any claim that you have against RK agencies.
If they are having the decree in the drum place, and the court has found there is an nexus, and the court has given them liberty to take
to prove that nexus also.
Yes, to prove and take appropriate steps. Now, they instead of filing the execution, now they come with the suit.
Yes.
Now they again praying for a declaration.
Yes. that whatever we've done is now they're trying. So this declaration will undo my decree from the beginning. They might as well have asked for recalling of my decree. They haven't challenged the decree at all. They accept the decree. A declaration that the plaintiff was entitled to exercise its lien. So this whole issue of lien is re-argued. Now, did the plaintiff have a lien? Did the bank have a lien? Exercise its lien and adjust and or set off the fixed deposit proceeds against the dues of and or claims against SL Sethi Liners and Drum Place Limited, and had rightfully and validly made such adjustment and or set off. Well, a declaratory prayer cannot have so many alternatives. Who is it? Is he asking that I have a declaration, the bank has a lien as against RK agencies? Is it saying the claims of SL Sethi Liners? It should be SL Sethi Liners Limited. I asked this question to the witness also. It looks like it's as if it's one company, SL Sethi Liners and Drum Place Limited. It's SL Sethi Liners Limited is a company and Drum Place Limited is another company. And rightfully and validly made such adjustment. So they have to say when did they make them. And prayer B is really an attachment order they're looking for. Perpetual injunction restraining the defendant from executing. So this, normally you cannot restrain someone from a legal proceeding under legal proceedings. But what they've done is now they put in the money. I can't say anything. The money is there. My decree is being withheld. But even if you look at it one more way, no one thought it will take so long. 20 lakhs is their claim. They could have adjusted 20 million rupees. And now my decree is much more than that. Now, by now, because of 40 years have passed since then. So now my decree is much more. But in any event, as far as your lordship and this suit is concerned, there is no question of reopening my decree. I've got whatever I've got. My counterclaim will be based on the fraud and the misrepresentation made by the bank, which has led me to, I have suffered loss for. My interest, so I'm getting whatever I'm getting from the first decree. But if these other facts were before the first court, then certainly my decree, just as a simple mathematically, it would have been much more. They said that, and that was the submission made by senior counsel also, because of the deblocking, there was no interest.
Correct.
And now they show the manifold. That's why when I began my argument yesterday, the last day, well, I was taking pains to show that when they made the judge's brief, they slipped in the second manifold as if it was a part of my written statement. So I had to make that clear because you don't know where this will roll and go at the end. So now, before I proceed with the argument further, my lord, may I show what was their stand taken before the Supreme Court of India? No. No, it's all there in my iPad. I'm just not used to seeing it. I'll tell. Before the Supreme Court, if my lord comes to Exhibit 17, 117, that's follow page 600 and. I will just give me 1 minute. Synopsis, it's a key page. No, mine is marked. Give me a minute. Volume 4. Yes. I'm sorry. My lord takes volume 5. No, just before that, if my lord takes the earlier volume volume 4, page 575, just one page I want to show. Volume 4, page 575. These are the grounds of appeal before the division bench. Just ground 23, that's 575. This to show what was the stand taken before the division bench. For the rate of interest awarded by the learned trial judge is also not tenable in law, because the defendant is not bound to pay any amount on account of interest, as by the order of the Reserve Bank of India, that account was immobilized and locked, and the bank could not employ the said money for earning any profit. It's as if they had taken my cash and put it in a little box and it never grew. The fact is the bank made money on this account.
Yes.
And this order, Reserve Bank blocking order.
Page 78, first
Hmm?
First
Well, volume 1 is with my lord, page 78 is the deblocking, and blocking.
deblocking.
Yes.
Yes, deblocking 78.
78 is the deblocking. I wanted to show my lord the blocking.
Exhibit 2x2.
The blocking. Punita, I showed it. Punita. Sokale powerful list of dates. It's in my list of dates. 86. Yes, page 31. Volume. Page 31. I'm sorry. Then I'll come back to the Supreme Court. Page 31 is the permission where they declined. RBI declined the bank.
Deblocking was on.
This is the
deblocking.
This is the deblocking 5th September 1986.
No, deblocking.
No, that was the blocking.
Deblocking on 25th July.
Deblocking the
25th July. 26th July.
Yes. Deblocking was made on 26th July 2006.
And blocking?
Blocking was 5th September 1986. That's page 31. And deblocking is page 78. Both in the same volume.
Dated.
Refusal of permission.
That is 5th September 86.
5th September 86.
So 5th September 86 till 2006 it was blocked.
Yes. It blocked as in, that's what I want to show. What was it? Page 31, 5th September 86.
Yes.
But before that, if I may just digress one last time, page 29. This is when the Reserve Bank refuses permission, because this is a main thing that they never got this permission, the bank. Page 29. I'll just quickly place this letter. It will have some
RBI
letter. Now, please refer to your letter dated such and such, November 85. The current exchange control regulations do not permit remittance from India towards recovery of dues of foreign borrower of overseas branch of Indian banks from amounts held under lien in India. This is the end of the story, really. Then, accordingly, we are not in the position to accede to your request. However, we shall be glad if you please to furnish us the following particulars. Now they've got a clue. They took all the particulars of RK agency and put on ED case. Now your lordship is dealing a lot with these cases, so I'm saying. So then they wanted particulars of RK agency and Satya. And my lord, page 30, this is a very telling request. Whether permission from Exchange Control Department of RBI was obtained by the Indian company or central bank before creating a lien on the deposit of 20 lakhs. So even if you had to do it at that time, without the permission, it seems that a lien could not have been given. Then, now that they got all these, perhaps they got all these information from the bank, page 31, 5th September, they're writing. This letter was of earlier letter.
Earlier letter was
January 14.
January.
14. 14. 1/4. January
16 January 2006.
Year
18 January
1986. Then this is in September.
14 January 86.
Yes. And page 31 now. Immobilization of the account in the name of Khanna and Company RK agencies. Whereas the Reserve Bank of India considers it necessary and expedient for the purpose of securing compliance with the provisions of FERA and the rules, etc. Therefore, in exercise of powers under subsection 3 of section 73, the Reserve Bank hereby directs that until and unless you are directed, no withdrawal or payment from amounts lying in the captioned account is allowed, and the said account is not closed or transferred to any other office. This was the order. So it didn't bar any interest accruing on that account. And the result ultimately, page 78.
In the earlier suit, first suit,
Yes.
where you got the decree, the bank is not having the counterclaim. Bank was having any counterclaim?
No, no counterclaim.
So how
No
the
count.
division bench?
The division bench was kind. They came with a decree and then they said, but now with that, by lordship will see what happens in before the Supreme Court, volume 5. Volume 5. Synopsis. No, 700.
Yes, 345 matter है क्या?
Volume 5.
अच्छा.
Your lordship has a 345. I
Okay.
wanted only today to finish this judgment. Next day I will just give my notes and list of dates and then I'll go on to my counter claim. Well, at 698, just up to the Supreme Court if my lord permits. This is their SLP from the order of Justice Oshim Banerjee. 698.
Yes.
The present petition is limited to the question whether the petitioner bank's right to set off, adjust the deposit lying with it towards the outstanding debt is contingent upon the permission of the Reserve Bank of India. Now, Supreme Court dismisses this SLP. So they were asking exactly this. They are saying permission is not required. Is it? This is the first clue. This is a 698.
Petitioner bank is entitled to set off the deposit made by Kannada toward it. Yes.
So they said this is the only limited question that was permission required. Then question B, page 698 at the bottom of the page, question B. Whether the petitioner bank has a lien over the securities received from the customer in ordinary course of business and whether the petitioner bank has a right to set off the proceeds in respect of any balance that may be due from the customer, by their own showing, from the customer by way of reduction of the customer's debit balance. If I had a debt, undoubtedly under section 171, they would have a lien, the bankers general lien they would have had. But there was no debt and that their witness confirms. So this is the thing. And then page 700, my lords will see what they represent to the bank, to the Supreme Court, page 700. The first event in the list of dates, right? Drum Place Limited and SL Setia Liners Limited, both belonging to the House of Setia group of companies, jointly owed a sum of rupees 1.6 something million to the London branch. The petitioner bank has taken civil action against both the companies in the English courts, in addition to filing criminal complaint against Drum Place with Scotland Yard. Now, this is the misleading sentence. The suits against both Drum Place Limited and SL Setia Liners were decreed in favor of the petitioner. And during execution proceedings, Drum Place was ordered to be wound up. Then they described the
how they're telling the execution proceeding? How they're telling execution proceeding?
In England in 1986.
We do not know.
We do not know. We came out in the cross-examination, it comes out. Then finally, my lord, just what they pleaded in their 733. This is one of the grounds. 733. Because ground P, because the Honorable High Court failed to appreciate that once the account of SL Setia Liners stood transferred to the petitioner's bank, International Division, there would be no requirement for seeking approval of RBI for transferring the division and adjusting it towards the debts of SL Setia Liners. So they're trying to reopen the issue of whether RBI permission was required or not. So this was what they said, and the page 1 of the first volume is the Supreme Court order. I'll just finish there for today. Supreme Court order, page 1, it goes on to page 2. Yeah. Page 2, rather. We do not see any ground to interfere with the impugned order. The SLP is accordingly dismissed. However, the time for 6 months stipulated by the judgment of the High Court is extended by 2 months from today. That's all. And they did not interfere.
Thank you.
Now, the most crucial part is when your lordship will give me another date, whichever date.
Yes. Record. counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed and the matter appear on और तो पहले नहीं है
Whichever is the earliest date.
17 June 3:45
Kavit?
or 22nd June.
June.
17, 22nd and 24 3 p.m. 17, 22 and 24. ठीक है 24 3 p.m. हो गए दोनों 3:45.
3 o'clock or 3.
No, 24 June 3 o'clock, 17 and 22 3:45.
Otherwise, if there are any 3 o'clock plots, that at least because I'll definitely finish in 2.
I have checked it. It's only 24 June. That's why before that I have given 2 dates.
17th will
17 and 22 3:45 and 24 3 p.m.
Great.
Number 3.
Yes.
But I am for the respondent.
Who is for the petitioner? Yeah, otherwise, the matter can be continued. कौन है जिसके साथ? No junior.
Yeah, Joseph.
Hmm? Nobody is there for not. None appears, though the matter is specially fixed at 3:45 p.m., but none appears on behalf of the petitioner. So appearing for the respondent. Respondent, case is adjourned. Let the matter appear on. Let the matter appear on 9th June. Next.
For your lordship, Mr. Kuto was leading me, lordship recall.
Anil Bajaj versus State of West Bengal.
Yes. Kuto was leading me in this matter, your lordship recall. This was that matter with respect to today my learned senior was supposed to submit for the respondents. We had already concluded our submission. This was with respect to the Kolkata police occupying my property right from 1970.
Yes, you are appearing.
But Mr. Samanta has been engaged, Mr. Jayanto Samanta has been engaged. In this matter. Mr. Jayanto Samanta has recently been engaged, since Mr. Bandopadhyay is no longer appearing. We will like to file our affidavit, Milord.
That, your lordship, I will object to because there was no leave, first of all, to
What
file
affidavit?
Milord, there are ample amount of documents, Milord, which are required to be placed before your lordship, Milord. Milord,
you not file the affidavit in
no, Milord, not
Milord, opportunity was granted, Milord, on previous occasions. Your lordship said
opportunity
that
was granted, Milord. I have taken specific instruction, Milord. This submission was made, Milord. I could not object on the last occasion because I was not aware of the facts. Milord, I have spoken to my learned advocates, Milord, who are engaged in this matter, Milord. As according to instructions received from them, Milord, they prayed for time. They prayed for leave of lordships to argue on maintainability, Milord. Your lordship, Milord, was pleased to fix the matter on 21st, Milord. On 21st, Milord, it was submitted that we chose not to file our opposition, Milord. But, Milord, there are ample amount of documents, Milord, which needs to be placed before your lordship, Milord, for consideration, Milord. Milord, we would like to place those documents on record, Milord, and
they waited for 3 months to file their opposition.
Milord,
Your lordship specifically inquired, do you want to file an affidavit? Then they declined, saying that no, we are at the point of maintenance.
We have prepared an affidavit in opposition.
Though the petitioner has argued the matter, petitioner has concluded the matter, concluded his argument, Now the defendant has filed the affidavit in opposition. Let the affidavit of reason be kept with the record, subject to payment of cost of rupees 10,000 to the State Legal Service Authority within a week from date, full stop. The plaintiff has liberty to file reply to the affidavit in opposition within 2 weeks thereafter, 2 weeks from date. List the matter on 10th of June 2020.
We did not.
Next.
Could a time be fixed, Milord?
Yes.
Could a time be fixed, Milord? It's for them. Kindly see, Milord.
Time में कोई है 3 बजे.
Your Lordship would see the corner. It was fixed at 3 p.m. Your Lordship gave the
We
entire.
did not fail any timeline, Milord. We did not fail any timeline, Milord, set by your Lordship, Milord.
Yes.
Milord, we did not fail any
Specific
timeline. Milord.
orders are there that they would not file a reply.
This court at 45
I
minutes
prayed
has
before your
looked at
Lordship.
the time for hearing. The petitioner has concluded the argument.
Milord, I prayed before your Lordship before
Correct.
this started.
Okay, no problem. I have not dismissed or I have not, yes. 23rd June at 3 p.m.
Your Lordship, to mark it as a part heard matter, but your Lordship part as complete.
Next.
So it has been already marked part heard
Next.
on the last
next.
occasion. লেখা আছে অর্ডারটা দেখুন.
Grateful, Milord. I'm grateful.
Yes. Yes.
Grateful, Milord.
Yes. You are appearing? Who is for the bank? State? Deepnath Chaudhary? But today there is a bar resolution, otherwise I could have been taken.
He said the report has come and the report is in my favor, sir.
Where is the report?
With them, they did not supply that report. They just told that the report has come and it is in my favor.
Though the petitioner is appearing in person, but none appears on behalf of the state due to the state for the due to the resolution taken by the bar. Case is adjourned. Let the matter remain in the list.
So on the top.
Yes, remain in the list in the same position.
Much all.
Yeah, next.
Number 6. For the petitioner matter of this rectification appearing for the first time. Someone has a two affidavit of service. Showing the service of the rectification and the second letter to mentioning notice with matter directed. First, the two affidavit of service matter. So this rectification matter, the subject matter of the challenge is the letter dated 16th March 2026, which is at page number 34, which have been most illegally mailed and falsely mailed and incorrectly mailed issued by the respondent.
32?
36.
36.
First, I will be showing my lord this letter. Thereafter, I will be showing my lord all the documents, my lord, support of my submission.
What is the 36? What is this? Passport?
34. Sorry.
34.
Letter dated 16th March.
Passport application, so and so, so and so. Your file has been closed due to call.
With father's
Name change.
Times, called but no response, thoroughly incorrect.
You may however wish to apply the press passport with all documents and required to fee at any time.
Now, my lord will kindly take a page number 16.
Where is the other side?
This is the.
But today is the bar resolution. How the court can take without their absence? If it is not bar resolution, the court could have been taken the matter.
I can make my submission.
Huh?
Just facts if I can place.
You will place, but where is the other side?
Other side is not.
Though the petition is present, but none appears on behalf of the state, case is adjourned, let the matter remain in the list. Next.
Same position below. Item number 7.
In any matter, both the parties are there. Affidavit of service we kept with the record. In any matter, both parties are there.
Actually, only item number 13. I want to I'm facing difficulty for filing my vakalatama on behalf of the bank for the respondent. Item number 13.
Which matter?
13, my lords.
13 of origin side?
Yes, my lord.
Why? You are applying for?
HDFC Bank, my lord. Respondent, my lord, 6, 7, 8, my lord. My lord, the issue is that, my lord, since my lord, they have met the party, the branch manager, HDFC Bank Limited, all. So the department is not accepting, my lord. One line order may be.
Why?
My lord, I have approached the department. Okay.
Why bank is not accepting?
Bank is not, my lord,
Eh,
the
why
department,
the
my lord.
department is not accepting?
My lord, the respondent number 6, they have made the party the deputy assistant.
I am the assistant vice president.
Yes, my lord.
Of
My
the
lord,
HDFC bank.
My lord, actually, but the fact is that, my lord, they have made the party of the branch manager. Particularly, this branch has no branch manager designation.
You do one thing on come on the matter will be taken up. I will advise to correct the cost title. Then you submit it.
My lord,
Grateful, your lord.
it's a very extreme urgent matter. Please grant leave for appellate side. My lord, 7 petitioners' name were deleted from the SIR list, final list. They were under adjudication, and after the final list were published, we found out that their name have been deleted. So the tribunal is not set up, and they have the election on 29th on the second phase. So my
You
lord,
preferred an appeal.
yes, my lord, we have done
Where
everything.
you preferred an appeal?
There is no tribunal, so we have.
Why? Who telling that there is no tribunal? 19 tribunals are there. 19 tribunals are there. 25 lakhs disposed of. 139% has been found genuine. It has been allowed. You not filed an appeal.
My lord, we are.
So what is your prayer? So. Madam, you have to prefer an appeal before the appellate tribunal. If the appellate tribunal not considering, then you come. This court cannot because Supreme Court. Supreme Court directly there's a direction we cannot entertain your writ application of the SIR matters. Okay, appeal is pending, then it can be. Petition there. अभी हाँ Okay.
CI portal है, appellate tribunal.